exclusion list, my lord.
What is this, man?
Application.
Yes.
One of the respondent died, my lord. Name will
The
take
substitution application.
expunge petition, my lord.
Yes.
My lord, may I be permitted to mention one modification application filed in connection with
Application is whose order?
my lord's order. My lord's order.
Yes, yes. File. Hand it over.
But upon notice, I mentioned.
My lord, for admission, my lord, and along with application, my lord,
Please hand over.
Application for correction of your lordship.
my lord, paper book is ready. It may be included in hearing.
In what? Hearing. Hearing not now. Not now.
Application matter.
Yes.
Lordship, may I be permitted to mention an matter? It has been disposed of by your Lordship order. This application, this first appeal was against an order passed under section 151, restoring the possession.
So this is an application or to be mentioned, under to be mentioned?
Lordship, it has been disposed of. Lordship, the predicament I am facing is there was an order of restoration of possession against which we came into appeal. Lordship has pleased to dismiss it. Lordship, after that, we have tried to contact the respondent, but every time we go to his house or call, he is not picking up. His door is locked. He has been absconding. We have took the neighbors. We have asked the neighbors. No one is there, Lordship. Lordship, the asset is still with us. Lordship, in few days, we will be standing in contempt, Lordship, of your orders.
Either you file a proper application or on to be mentioned, under to be mentioned, you cannot do anything. Then file a proper application seeking appropriate orders for this.
Lordship,
We won't. We are not in season of the matter in any longer. So we have disposed of the matter. We cannot take up the matter again. Yes.
But
Lordship,
order 41 for
I will
Yes.
file the
But
necessary.
another matter, my lord, if your lordship kindly considers, my lord, item number 88 of the today's list, my lord, it's a hearing matter. But the only difficulty, my lord, the petitioners, my lord, she's an octogenarian, my lord, she's suffering from cancer also. But if some precedence, my lord, could be given, but it's on a very limited scope of remand, my lord. Item 88, my lord. I've given a notice to the other side, my lord.
Not
mentioned-
possible right now. Not possible. So many matters are there. Why jump the queue? If you start jumping the queue, then others will also.
I understand, my lord. May I take my turn then next after some days, my lord? Then, if you lord.
Not right now. I mean,
I
Have
understand.
your lordship
I-
kind leave to mention, my lord? It was my lord's order to direct serve.
what is this application?
My lord, it was first in that appeal.
What
my
heading will it appear under?
lord, inclusion in the list, my lord.
There is no heading called inclusion in the list.
Lord,
Come prepared and mention tomorrow. Yes, next matter. Call on the list. Yes.
My lord, in item number 1, I appear on behalf of the appellant.
Take the microphone, ma'am.
My lord, I appear on behalf of the appellant, my lord. My lord, kindly sees, my lord, the order passed by Honorable Justice.
Special messenger cost has
Mal-
been deposited
my-
beyond time.
My lord,
That will accept. What else?
I'm praying for acceptance.
Attaining majority of 7 and 9, you have to file an application.
Well,
7 and 9 were minors.
That has been done by the respondents have filed the wakalat, my lord.
You had to put in you have done nothing. We directed you to deposit the postal cost for service on 12 to 16. You have not put in.
That's. I'm praying for acceptance of the bill.
That will accept and direct you to comply with the other parts. It appears from the office report dated June 16, 2025 that the special messenger costs have been deposited by the appellant beyond the time stipulated by this code. Full stop. Such delayed deposit is accepted and the office is directed to take steps accordingly. Full stop. Next para. The appellant shall take immediate steps for filing appropriate application in respect of the respondent numbers 7 and 9 having attained majority, seeking to sue on their own behalf. Full stop. The appellant shall also deposit the postal costs and other requisites for service of notice of appeal on the respondent numbers 12 to 16 within a week from date. Full stop. In default, let the matter be put up under the heading Lozima.
Yes.
You can check the report later on. 7 and 9 have attained majority. They have to file an appropriate application seeking to proceed with the appeal in their own name and put in the postal cost immediately, 12 to 16.
Grateful.
Non-prosecution? You are for the respondent?
And for the husband appellate.
Appel. Learned counsel for the appellant submits that the appellant does not want to proceed any further with the matter and files in court a written communication to that effect. Full next para. Such communication be kept on record. Full accordingly, FA 138 of 2024 is dismissed for non-prosecution. Interim order, if any, stands vacated. Thank you.
Due to my lord compromise, this matter is
Good.
grateful.
Mhm.
Lordship, in this matter, Lordship, I am appealing on behalf of plaintiff appellant. Lordship,
Yes.
passed preliminary order before Lordship on 11 June 2025, Lordship. And Lordship restraining the order, but Lordship in paragraph number 6, page number 2, Lordship directed that respondent and or their main and agents shall remain restrained by an order of injunction for selling, transferring, alienating, and or incoming suit and parting with possession of the suit in favor of the third party in any manner till disposal of the application. But Lordship, in my injunction application, they have started construction from the very beginning. And kindly have a look, Lordship, my injunction application pair. Only have a look, Lordship, kindly.
So what are you wanting now?
Lordship, only it's a construction or they are restraining from illegal construction on because they did not inform, they did not taken consent from us. And this is Lordship undivided, unpartitioned, undemarcated property.
That injunction was not granted. Then you have to file an application for modification. Application, the injunction application itself is pending.
In my application, pair was
Very well, your application itself is pending. We have not granted, at the ad interim stage, you have not granted any order regarding this nature character change. But at the final hearing, we may grant it. So, we'll direct your application to be listed under the heading application.
Lordship directed the matter will be listed on 6 July month, common month is July 2025.
But it appear will pass orders.
But Lordship,
we
the
have-
whole difficulty, Lordship,
We have
construction.
refused that order. On oral prayer, we cannot amend our order. Learned counsel for the appellant submits that in the ad interim order dated June 11, 2025, although injunction was passed with regard to sale, transfer, alienation and encumbrance of the suit property and parting with possession of the same in favor of third parties, no restraint order was passed regarding construction. Next para. However, we cannot modify our order on verbal submission of the parties. Since no ad interim order restraining the respondents from making construction was passed in the ad interim order, the appellant will be at liberty to make similar prayer at the time of final disposal of the application. We are informed that the application has been directed to be listed in the monthly list of July 2025. Accordingly, let the matter be listed in the said monthly list. Liberty to the appellant to renew his prayer at the time of final hearing of the injunction application. Next. In default বলেছি লজিক না ডিফল্ট হলে অফিসে পাঠিয়ে দেব
I pay for the respondent. This is that matter I had to bring the deed, but I've taken instruction. I have the draft deed with me, not the final deed. Lordship, I've had a word with Mr. Singh. The Lordship may give me 10 days or 14 days time so that I can take the certified copy out.
Unless when we will keep it
But after 2 weeks, after a fortnight, Lordship may keep it so that I can bring
after
the
a fortnight. Then we'll keep it on 2nd of July.
My lord.
On the prayer of the respondents, the matter is adjourned till July 2, 2025.
Grateful.
When it will be listed under the heading, the application is pending.
Application is pending. Lordship may keep it in the same under the same heading, my lord.
When the matter will be listed under the heading application. We cannot block the forward spot
Oh,
forever.
Grateful.
In this matter, I beg to appeal on behalf of the appellant, my lord. There are 3 applications,
The substitution application has been filed.
my lord. Can 3, my lord.
Have you given a copy to the respondent?
My lord, it is for expansion on his letter, my lord.
Even then, you should have given a
But
copy to
They
them.
have not appeared today. On the earlier occasion, they appeared.
Have
but
you
I-
given a copy of the application to the other
my lord,
side?
yesterday it has been filed.
The appellant shall serve a copy of which application?
Can 3.
Of
The
can
earlier,
3 of can 3 of 2025 to the respondents, indicating that the same shall be listed along with the other applications on July 8, 2025, when an affidavit of service to that effect shall be filed.
My pardon to lordship.
2 was appearing, you can serve his advocate.
Pardon,
The
my
other respondent number 2 appeared on the last occasion.
Respond.
2 appeared on the last occasion, you can serve his advocate, but you have to serve the others.
My lord.
Next.
Now, this is that application under section 5, condonation of delay, my lord.
Yes.
Now, my lord, the cause title has been amended pursuant to your lordship's liberty. So 95 days, my lord, delay, because, my lord, wrongfully we had filed a 227 because it was a combined order. My application under order 23 rule 1 was dismissed, and under the same order, order 7 rule 11 was taken up and allowed. So, my lord, wrongfully, my lord, we filed a composite
Yes, what do you
challenge.
say?
What he has stated is correct, but he has not stated in the application. He would have easily stated that.
It has not stated in the application.
Opposing, but
Well, AJ,
he,
but,
he
I think
actually
I've
went
said.
there in revision.
What have you
I
said?
pointed out that it should be appealed. They have filed the appeal. Section
Para-
14 Limitation Act. Finished.
No, they have
Paragraph
stated that
paragraph 5 I have said, and the original
para 8, 9 also.
paragraph.
But wrongly they have done, they have not stated.
Hey, on mistaken advice. Paragraph 6. Paragraph 6.
These technicalities, your lordship knows.
I have not catch this.
The ground taken in the application for condonation of delay is
Kindly do not record our no objection.
no.
Grateful.
We won't record your objection.
No objection. No objection. Let it be court order.
The ground taken in the condonation of application condonation of delay in the application for condonation of delay is that the appellants erroneously preferred an application under Article 227 of the Constitution of India against the impugned order, since by the self-same order, an application under Order 23 Rule 1 of the Code of Civil Procedure were dismissed, and the application of the defendants under Order 7 Rule 11 of the Code of Civil Procedure was allowed. Full stop, next para. Upon hearing learned counsel for the parties, we find that there is an ingredient of Section 14 of the Limitation Act involved as well. Full stop, in any event, we are satisfied that the grounds taken for the grounds made out for the delay is sufficient. Full stop, accordingly, can 1 of 2019 within bracket old number can 8546 of 2019 is allowed on contest, thereby condoning the delay in preferring FMAT 813 of 2019. Full stop, this much. No orders to cost. Now then the appeal has to be taken.
Yes, but the stay application, it is an application for
FMAT না ওটা FAT হয়ে গেছে in filing FAT number 513 of 2019. Yes, what is the other applications?
The other application is actually, my lord, an application for stay, my lord. There is no question of the suit has been dismissed now.
There's no
So-
scope.
so
We'll
the
direct you to all the respondents are appearing. You are
Yes, my
you are the performer.
But
You are not German.
Other respondents are appearing.
Only thing is that is it the thing consideration is Mulad, that whether there is a necessity for direction for paper book here.
No.
Because I'll tell you is why, because Mulad, perhaps what
Order 7 Rule 11 rejection.
yes, but
No
what
necessity.
no necessity. And what
No, paper books will paper books will contain the relevant papers. That will be informal.
all papers are here.
Informal
So-
paper
so
book,
the
your lord,
only
different
thing
treat-
that is not here is
Informal without
subsequent
comparing.
events, subsequent events.
the only thing that is not before your lordship, which I am sure, Mulad, these are orders of court and his documents, some of his documents. Of course, he cannot deny that because
We
he's
can only look into the plaint.
yeah, exactly.
And 711 and objection.
But the subsequent, that's what I'm saying. But now this entire thing has become academic now. Because, Mulad, for the reasons I told your lordship, is that because, Mulad, CIRP initiated on
So
the
those will
self-same
not be a
cause
part of the
basis.
paper book. You can advance your arguments when we hear the matter.
So,
But the scope of the appeal is regarding
correct.
whether
That's right. So, Mulad, what we'll do is, Mulad, I will
records we are
show-
dispensing with.
Yes.
All the respondents are represented.
Yes, my lord.
Sure.
Yes.
Yes. You're also sure that we both sides are sure.
I do not know.
All.
Well, let Mr. Sen, I think, start. What I'll do is, I'll just take 10 minutes to just to show that
তোমাদের ব্যাংক
after he's come to.
না না তোমরা ব্যাংক রেফারেন্স
আমি
What
ব্যাংকের
about-
He's for the bank.
ও ভেরি ওয়েল মানে দে আর রেফারেন্স
You're for the officials already.
all are there মানে
Acha, since all the parties are represented through their learned advocates, comma, service of notice of the appeal on the respondents is dispensed with, full stop. In view of the short ambit of the appeal, comma, the formality of calling for the trial court records is also dispensed with. Full stop. Next para, the appellant shall prepare and file informal paper books without comparing with the requisite number of informal paper books without comparing with the records within a fortnight, Mr.
yes
Within a fortnight from date, with advance copies to the learned advocates appearing for the respective respondents. Full stop. The appeal be listed for hearing in the monthly list of July 2025, the next month.
Well, with your
can it
lordship,
be 3 weeks instead of fortnight my
So then it won't come in the monthly
Very
list of
well.
July. Do it within.
would your lordships just allow me to just to file a compilation of those documents?
Yes, yes.
If your lordship allows me, I'll exchange it between with Mr.
Exchange it. Acha,
I want to
যেখানটা
come-
বললাম requisite number of informal without comparing with the records, incorporating all relevant documents. Full stop. তারপর একটা line add করে দাও. It will be open to the learned advocates for the respondents to point out to the learned advocate on record for the appellant. In the event, according to the respondents, any other document than those on the record are necessary for the purpose of incorporation in the paper book. Mr. Shen, if you feel those are important, then
No, because these are the subsequent events. I'm being very
no,
candid.
subsequent event.
subsequent event
Very,
cannot
very
come.
candid.
No,
Because
no,
the question before
No.
the lordships is, my lord, because your lordship said that in
subsequent event we won't.
the subsequent event
না
being
ওটা ওই লাইনটা কেটে দাও কেটে দাও কেটে দাও ওই লাইনটা
Plain has to be
then, my lord, I will then just rely upon at the time of hearing.
that
That's
but
it.
it's subject to
if it's a certified copy you can, but circulate advance
Because
copies.
what I indicated to your lordship is now this
Hand over certified copies of
that
what?
appeal is now because
So Banerjee, whatever documents you want to relay, give copies to them in advance.
copies to the other side and I'll rely upon it.
Those will not be a part of the paper book.
No, that's not a problem. my lord.
Affidavit of service file to be kept.
That's what I'll make a compilation and serve it upon my friend and address
Don't make the compilation too big, then we won't look
it.
at it.
Small,
Supplementary paper.
extremely small, without the judgment. Extremely small.
Yes, next.
I'm grateful.
but the amended cause title may appear in the cause list also.
Yes, it is not appearing. Lordship.
Very
Whatever amended cost title দিতে হবে কম্পিউটার সেকশন থেকে করে মেমোটা দেখে করে yes
Item number 7, I am appearing on behalf of
Lordship,
the
in this
petitioner.
matter, I beg to appear on behalf of the respondent.
what is the application for?
This is application for injunction, my lord, to restrain the opposite party from alienating the property which has been allotted to them
Acha,
according to the succession certificate.
petition you have withdrawn the original succession certificate along with original exhibits by replacing them with photocopies in the trial court. You are the petitioner.
I am here, I am petitioner, my lord.
There you are. Who was the petitioner?
I am,
He was
You had withdrawn the copies.
most probably. Lordship, most
Yes, the
probably.
petitioner means because you are the appellant.
yes,
here.
my lord.
Most probably.
You have to replace those documents, the originals,
Lordship, I undertake to file
within a week.
document within a week.
Within a week. File it in the department. Then let us take up the injunction application. Yes.
Lordship, owing to the circumstances of this particular case, an affidavit in opposition is required to be filed.
We are considering only whether we grant ad interim injunction. We'll direct you to file. Yes. What is the
My lord.
matter about?
This is the application for succession was filed by my learned friend,
Granted.
granted.
You have asked for injunction.
I am asking for injunction not to alienate or encumber the property which has,
Fair enough. Fair enough.
Yeah.
Fair enough.
because I have added.
We'll restrain you from dealing with or creating third party interest in
My lord.
respect of the subject matter of the succession certificate.
Lordship,
For a limited period, you will file your opposition. and-
there exist certain circumstances. Lordship,
Like
succession certificate was granted in the year 2018. Already 7 years have been elapsed. Already the succession certificate had been utilized by the respondent.
the appeal was filed after 7 years.
Appeal was filed
Appeal
within
was
time.
Filed within time, but
Within
due
time,
to
but
date of the
application for injunction was filed within this month. Lordship, after the expiry of
So
7
you have
years.
already dealt with the properties.
Lordship, regarding the movable monies and lying with the accounts of the deceased already been utilized.
So we'll restrain you from further dealing with the property, and you come back disclose in your affidavit in opposition whatever is there.
Lordship, kindly appreciate, Lordship, already they have cited
Apart from money, there were certain debts and securities. You've already utilized those.
Lordship, most probably
Most probably won't do. You cannot write most probably. You disclose in your affidavit of assets. Affidavit in opposition, what you have done. Heard learned counsel for the parties. Full stop. Learned counsel for the respondent submits that some of the properties, immovable and movable properties, which are the some of the movable properties which are the subject matter of the impugned succession certificate have already been utilized. Full stop. Next para. However, comma, learned counsel for the respondent is unable to apprise the court as to the exact particulars of such dealt hyphen with properties. Full stop. Next para. In any event, comma, since the appellant stroke petitioner has made out a prima facie case for hearing the appeal on merits, and the appeal has been preferred against the grant of a succession certificate, comma, the circumstances indicate that a strong prima facie case for hearing the appeal on merits has been made out. Full stop. In view of the admission of the respondent that some of the properties have been dealt with,
Lordship,
comma,
indulgence, Lordship. No immovable property has been dealt with.
movable. Succession deals with movable only.
Lordship,
Some of the properties have been dealt with, comma.
Lordship,
We are
immovable
of the opinion that there is extreme urgency for grant of injunction. Full stop. Accordingly, the respondent and or her men and agents are hereby restrained from further dealing with and or alienating and or encumbering the subject property covered by the impugned succession certificate till disposal of the application. The respondent shall file her affidavit in opposition within
2 weeks.
A fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on July 14, 2025.
Paper book has already been filed, my lord.
Paper book. Acha, arekta direction kore dao. Since we also find from the office report dated June 17, 2025 that since the respondent had withdrawn the original succession certificate along with original exhibits 1 to 4 by replacing those with photocopies of the said exhibits, comma, the appeal cannot be made ready for hearing. Full stop. The respondent is directed to ensure that all the withdrawn exhibits are replaced, are filed in the department of this court at the earliest, comma, positively within a week from date, for the purpose of completion. Full stop. Next para. Upon such original exhibits being re-filed, comma, the office shall furnish a revised report as to whether the appeal is otherwise ready for hearing. Full stop. Such exercise shall be completed within the next returnable date. Affidavit of service filed to be kept. When the injunction is taken up, within that this will happen, and if there's a note, we'll consider whether the appeal can. Yes.
Item number 8, Milord. I'm the respondent wife, Milord. The appellant, Milord.
You are the respondent here.
Wife.
You are for the
appellant. Applicant.
Applicant,
Respondent. Respondent in the appeal.
Out of station, my lord.
Who is out of station?
Advocate on record of the appellant, my lord.
Who is the advocate on record?
My lord, Sohini Mukherjee, my lord.
Sohini?
Oh, long ago, Milord, I served the coffee. Not the today. It is only, Milord, the last more than 1 year.
Sohini Adhikari?
My lord.
You are appearing. You are there. Unless you are a designated senior advocate, there is no bar in your appearing without the advocate on record.
I'm not, nothing, my lord.
Only, Milord, alimony
Is that,
pending.
kindly adjourn.
She has not given you a copy of the brief. You are also appearing in the matter. What is that?
Application, this application.
The application,
That is being moved. Let us hear it. What is the application for?
Application for, Milord, alimony pending.
You are the respondent in the appeal and the husband.
In the appeal, wife. Milord, the
Oh, achha, respondent wife.
Maintenance should already.
Applicant.
The appeal has been, you obtained a divorce decree.
No, Milord, I did not file, Milord. Husband filed.
Divorce suit was dismissed.
Against this file in the appeal.
This is an alimony application.
Alimony application.
Have you filed your affidavit of asset?
No, more than 1 year, Milord, the lower court, Milord, directed, but last March 2024, Milord, given, Milord,
that was
alimony.
That was alimony.
That is, Milord.
That is pending.
If your lordship interested, but prior to my lord file this application, my lord husband file one application, disposed of. He anticipated that my lord I will claim my lord the
This is not a question of anticipation. We have to be independently satisfied as to your assets and incomes.
So,
So you have to file your affidavit of asset. Do that. The present application bearing Can 2 of 2025 has been filed by the respondent wife for grant of alimony and litigation costs. First of next para, the respondent wife is directed to file her affidavit of assets within a fortnight from date and serve a copy thereof to the learned advocate for the appellant stroke opposite party stroke husband. First of next para, a composite affidavit in opposition thereto, comma, dealing with the allegations made in the maintenance alimony application as well as the affidavit of asset of the wife, comma, shall be filed by the appellant stroke opposite party husband within a week thereafter. Week thereafter, full stop. Reply, if any, shall be filed. The appellant stroke opposite party husband shall also file, comma, along with his affidavit in opposition,
Yes,
comma, the husband's affidavit of assets, full stop. A composite reply thereto, comma, if any, shall be filed by the respondent stroke petitioner stroke wife within 1 week thereafter. Full stop. Next para, the application shall be listed for hearing on July 21, 2025.
Under the same heading, my lord. No, for
Has to be under the same heading. It's an application.
Lordship, I am for the appellant twice. What happened, Lordship? Marriage took place in the year 2007. Thereafter, two sons were born in the year 2010 and 2016. In the year 2021, husband filed one application for divorce in the court of First Court at Barakpur. Suppressing that fact, again he has filed another suit for divorce in the court of First Court at Barasat. In the second, during pendency of the first matrimonial suit for divorce, he filed the second suit for matrimonial suit for divorce. In that suit, he obtained an ex parte decree.
In the second suit or the first suit?
Second suit. Second suit while it was pending. In the second suit.
First suit was pending, you were contesting.
No.
In the first suit, you were contesting.
Wife was residing in the matrimonial home. Even then, summon was not served. In both the suit. In the second suit, obtained the ex parte decree of divorce. Husband is an employee.
First suit is still pending.
After filing, it was dismissed for non-prosecution.
That he could have, but
summon was not served in both the suit. Lordship, suit was decreed ex parte. Now this application appeal was filed along with an application, section 5 application.
Serve a copy.
Thereafter some development, Lordship, in the last order, kindly have a look.
Yes.
The Honorable Justice Mudresh Khoshak, the matter was sent to mediation. Mediation failed. Though husband appeared to actually appear, mediation failed. Thereafter, third time appearing. I am the change, Lordship.
Were you enjoying any interim order previously?
No, Lordship. It was decreed ex parte. It was I came to know when father-in-law of the appellant wife.
Then you should have given a notice to the other side before mentioning.
I have informed Lordship. Notice was I have tried to serve the notice. She was not available. I have informed her through phone, Lordship. WhatsApp also. His Moshimi Bhaval and Parthipathi is apparent. Lordship, kindly make it some.
We'll take it up on Monday, give another notice.
I have some liberty. Kindly take it up Tuesday.
Tuesday we'll take up. None appears for the respondent at the time of call. First of learned counsel for the appellant submits that suppressing the fact of a previous divorce suit at the instance of the respondent husband, comma, the respondent filed a second suit which was decreed ex parte against which the present appeal has been preferred. Full stop. The first suit was ultimately dismissed for non-prosecution. Full stop. Next para. It is further pointed out by learned counsel for the appellant that the appeal was initially sent for mediation. Full stop. However, comma, upon mediation having failed, comma, the same is appearing for the first time before this court. Full stop. Next para, since the respondent remains unrepresented today, comma, the learned advocate on record for the appellant is requested to serve a notice indicating that the matter is appearing in the list to the learned advocate on record for the respondent by tomorrow, full stop. The matter shall next be listed under the same heading on June 24, 2025. When the appellant shall file a receipt in that regard. You serve a notice, give a receipt. If they don't appear, we'll take up.
The 10 I beg to appear on behalf of the appellants.
Yes.
So my lord, just kindly see the last order passed by the my lord Justice Madhuresh Prasad and my lord the Supratim Bhattacharya on 9th of September. So my lords, in the meantime, my lords, during
Have you given a notice to the other side?
I have served.
You are appearing.
Yes, my lord, Mr.
On the last occasion, somebody appeared.
Sanjeev Mitra.
Today, it's appearing on your mentioning. Have you given a notice of mentioning?
Well, along with the mention, I am told by along with the mention.
Priyanka Chunari is your advocate on record. So it's appearing at your instance. You should have given a notice to the other side. Give a notice, come back on Monday. None appears for the respondent. Full stop. Since the matter has been listed at the instance of the appellant, comma, the appellant is directed to serve a notice to the learned advocate on record for the respondent indicating that the matter is appearing in the list and file a receipt in that regard on the next returnable date. Full stop. The application shall be listed next on June 23, 2025 under the same heading. Come back on Monday, give a notice, file the receipt on the next day. If they don't appear, we'll take it up.
Get loss.
Under item 11, I beg to appear for the petitioner, my lord.
Yes,
My
Mr.
innocuous application for expeditious hearing, my lord, the respondents have entered appearance, respondent number 1 and 2.
In the Vakalatnama, respondent number 2 has, the name has been entered wrong.
Yes, 17th of June, my lord, 2025. That.
Yes, you have checked up. Good.
Now, Mr. Aditya Shankar Rai was there, my lord. He was there in court, my lord.
We'll direct him to file a proper Vakalatnama in the meantime and we'll pass necessary directions for.
And the notice. But only one thing, my lord, since I have been instructed by the Legal Services Committee to appear. My lord, difficulty is this, my lord, kindly takes paragraph 6, my lord. My lord, though
which can?
Can
1 or 2?
Can 2. It's an application for expeditious hearing.
As an injunction application is still pending.
That is pending and an order has been passed. They have undertaken that they will not dispose of the property. My lord, I am pressing for hearing of the appeal.
Yes, paragraph 6. What?
Paragraph 6. My lord, he has approached the Legal Services Committee, my lord. Now, there is an option of filing of formal paper book, but my lord, that will take some time. So, in this case, my lord, let the record be, let the records come through special messenger and the Calcutta High Court Legal Services Committee be directed to file the paper book, informal paper book.
Before mentioning the matter, did you give a notice to the other side?
My lord, I had a talk with him, my lord.
Who is appearing?
Mr. Rabindranath Mahato and Aditya Shankar Rai, his junior, my lord. But I just had a talk with him, my lord. In my next matter, he is appearing.
He knows that the matter is appearing. None appears for the respondent at the time of call. Full stop. When was the undertaking given?
In the last order, my lord.
This is against what? What order?
My lord, grant of probate, my lord. I applied for grant of probate. That has been turned down.
Granted?
No.
Refused?
Refused. If my lord directs me, my lord, I will cause a formal notice and let it be taken up on Monday.
Do that because we have to extend that undertaking till disposal. None appears at the time of call for the respondents. Full stop. The learned advocate on record for the appellant is requested to serve a notice indicating that the matter is pending in the list to the learned advocate on record for the respondents during the by tomorrow and file a receipt on the returnable date. The matter shall next be listed under the same heading on June 23, 2025. Full stop. The learned advocate for the respondents is directed to file a proper Vakalatnama on behalf of the respondent number 2 pursuant to the uh, office report dated June 17, 2025, within a week from date.
And for the plaintiff appellant. Suit for partition was dismissed on contest. Thereafter, the appellant paper is
This is appearing for the first time. Application appearing for the first time. You asked for injunction.
Injunction, Lordship. Initially, during pendency of the suit, there was an order of status quo, and it's
Will grant injunction. The appeal arises out of the dismissal of a partition suit. Full stop. We find a strong prima facie case for hearing the appeal on merits having been made out. Full stop. We are also apprised by learned counsel for the appellants that the appellants had enjoyed a status quo order during pendency of the suit. Full stop. From the averments in the injunction application, comma, sufficient urgency is disclosed. Full stop. We are also of the view that the balance of convenience and inconvenience is in favor of grant of injunction, and the appellants shall suffer irreparable injury unless ad interim injunction is granted. Full stop. Accordingly, the respondents are shall remain.
not all responses, respondent numbers 1 to 3 and 18.
1 to
3 and 18.
in the prayer you have asked for injunction against respondents 1 and 18 only. 1 to 3 you have not prayed.
1,
So-
2, 3 and 18. That was in the pendency of the suit order.
Restraining the respondent numbers 1, 2, 3 and 18 and or their main and agents from selling, transferring, alienating and or creating any third party interest in respect of the suit property till disposal of the application. Full stop. Leave is granted to the learned advocate on record for the appellants to carry out the necessary corrections to the prayer portion of the injunction application, comma, introducing the name, introducing the opposite respondents to opposite party numbers 2 and 3 as well during the course of the day. You amend your prayer portion. Prayer portion you have said opposite party numbers 1 and 18.
Lordship, I will make it to 1 and 18. I'm sorry, Lordship. I'm wasting this right.
ঘেটে গেল যেখানে যেখানে 1 2 করা যাবে তো করে দিন তাহলে 1 and 18 তাহলে করে দিন আর লিভ ইজ গ্রান্টেডটা কেটে দিন the appellants shall serve copies of the injunction application on the respondent numbers 1 and 18 indicating that the matter shall be that the application shall be listed for hearing on July 8 2025 when an affidavit of service to that effect shall be filed by the appellants.
Lordship, I appear on behalf of the respondent in this matter.
Yes.
Ishika fertilizer. Item 13 naam ta bolo.
Yes. What is the application about?
Yes, Your Lordship. Lordship, I have served Your Lordship the other side, and the other side is here.
This can one.
Yes.
You are enjoying an ad interim.
No, I am not enjoying the ad interim. What happened, Your Lordship? The plaintiff filed a suit for recovery of money.
Plaintiff means them.
Them. I am the defendant there. I filed a counterclaim, and in the counterclaim, along with the counterclaim, I filed an application in the nature of a mandatory injunction.
What sort of mandatory injunction?
That the machinery which I have taken from him
Yes.
has to be properly commissioned and work properly. Now that application, Your Lordship, has been dismissed. If Your Lordship kindly sees, I found that order, Your Lordship, is an incomplete order. Because once Your Lordship is said that mandatory injunction, whether it is passed or not, nothing discussion is there. If Your Lordship kindly sees the order which is under challenge.
The appeal was admitted.
The appeal was admitted. And after Your Lordship admitting the appeal, then Your Lordship, I have served Your Lordship to the other side. Your Lordship kindly sees.
Yes.
The last, second last order, last page. After second last page, last paragraph, after hearing. The impugned order, Your Lordship.
Second last page.
The order is order number 32 dated 12th of December 2024. Now, Your Lordship kindly sees the first page and the second page, Your Lordship, is regarding the recording of the submission.
Yes.
Second page,
After hearing starts in the
after
second
hearing,
page.
yes, yes, sir. After hearing the learned advocate on perusal of the record, it appears that admittedly one order was placed by the defendant to the plaintiff to the for supply of EOT cranes with grab bucket and it appears from the purchase order annexed with the petition that the plaintiff was liable to prove warranty against any defect, damage, improper material and poor workmanship for the product for 18 months from the date of the dispatch or commissioning and will replace all the defective items at free of the cost. And it will appear from the clause 6 of the purchase order that the commissioning of the work will be done under the supervision of the engineers and technicians of the plaintiff with the support of manpower provided by the defendant. And if the company awards to complete erection and commissioning job to the supplier, the same will be carried out by the supplier on mutually agreed rate. Therefore, it is clear that the commissioning work is done by the plaintiff. The plaintiff is entitled to the cost of commissioning at the rate of mutually agreed in between them. Admittedly, the defendant has paid the price of the crane and the plaintiff was entrusted with the commissioning work. And it is the case of the plaintiff that the crane was successfully commissioned on the site provided by the defendant, and it is the claim that the defendant crane is lying non-functioning due to the latches of the plaintiff. It is the further case of the plaintiff that the defendant has invoked the bank guarantee of rupees 5,10,000 without reams and reasons, and it is contrary. And in the contrary, it is the case of the defendant that due to the failure of the plaintiff to make the crane functional, the defendant was compelled to invoke the bank guarantee. Now the question comes whether the mandatory injunction can be passed at this stage. Therefore, the application is dismissed. So it's a fit case, Your Lordship, for the remand, so that Your Lordship, the application.
You agree to this, your Mr.
Yes, I'm Prasad Sapte, Lordship.
Mr. Prasad?
Yes, Prasad Sapte.
Sapre. Mr. Sapre, if you agree, we'll dispose of the appeal and remand it for adjudication on the mandatory injunction prayer.
Lordship, I differ. I beg to differ on this point, and law is very well settled. My learned friend had just harped upon few factual points, and he has read the impugn order in isolation. So there are two. First of all, Lordship, there are three cardinal principles of law while entertaining appeal on this order. That interim reliefs are discretionary reliefs, and generally the appellate courts cannot interfere with those discretions of the lower court. Second, appeal cannot be also preferred to change the view of the court. That's another important point. And my learned friend has, again, he has in parts mentioned, so I supplied the crane, which was worth of rupees 51 lakhs. And he has filed a counterclaim of rupees 95 lakhs. So Lordship, kindly refer the section 41 of Specific Relief Act when it says injunction when refused, and subsection H clearly says when equally efficacious relief can certainly be obtained by other usual mode of proceeding, then injunction can be refused. So in this case, what he has prayed for, if his application is looked at, he has only asked for proper functioning of crane. So the worth of this transaction goes back in the year 2016 and 17. I filed a suit for recovery. Then only after, to counterblast my legal proceeding for recovery, he moved this application. And now not only he moved the written statement, but he also filed a counterclaim of 95 lakhs. It's almost a double of crane price. So the court, and he again kindly refer the page 100 of his
Mr. Sapre, before going into all this, just show us one line of reasoning on the line that you have argued from the trial court's order.
Right.
One line on mandatory injunction. One line of reasoning, a single line.
Right.
Show us that, we'll dismiss the appeal.
Right, Lordship. For that, we'll have to go through the order from the beginning, which is at page 100. Whether your Lordship
beginning is the narrative. Beginning is the narrative.
Yes, absolutely. So, but lower court
show us one line of reasoning of the lower. You are right, Mr. Sapre. If we intended to grant independently mandatory injunction by setting aside the order, then you are right. We have to then give reasons, and we have to consider your contention definitely that alternative remedy lies in damages. So injunction is not maintainable. That we had to consider. But we are not intending to grant any mandatory injunction. We are saying that no reason, even in the reason regarding damages being alternative remedy, finds place in the impugned order at all, not a single line. Is this an order? Now the question comes whether any mandatory temporary injunction can be passed, and the court does not answer that and says it's rejected. One line of reasoning would suffice. We'll
Lordship,
remand it, Mr. Sapre. If
kindly,
you
kindly turn
ideally
on next page.
agree to the appeal being decided right now, only on that, remanding only on that ground, and he has to give reasons and do whatever. Or we'll grant stay of this.
So kindly just turn on the next page of this order at
That's a
103.
39.7 consideration. We have seen that.
So
That's a
kindly,
39.7.
Lordship, my humble request, kindly turn on next page of that order, which is continued at page 103. So it says petition under so and so is taken up for order. Both sides heard on the petition. It appears from. So all points were considered. Both
In the order 39 rule 7, it's a different consideration
right,
entirely.
right. So even in this order, all records were also considered, your Lordship. So all records, material which was put on record was considered.
No, Mr. Sapre, the difficulty is injunction is apple and that is orange, 39.7.
Right.
So you
right.
cannot consider the peel of the apple for considering whether the orange is good or not.
Right. So
These are different considerations. Sorry.
Lordship, fair enough. But my only point is that so lower court has considered all materials on record, arguments were advanced, and after that thorough consideration, this application was rejected.
What
Although
do you mean
it
exactly
may
by
lack some kind of
consideration?
reasoning.
What do you mean by consideration? Narrating the facts and the arguments of the parties is consideration. Not a single, we have never seen an order without a single sentence of reasoning. At least it could have been said, in my opinion, they are not entitled. Nothing. Now the question comes, like if you say, now we have heard Mr. Sapre and we feel his contingent should be turned down. It's like that.
Lordship, but again, so I repeat myself, Lordship, only for sake of detailed reasoning, but reasons have been also put on that what are the materials which lower court has
Sorry,
gone.
Mr. Sapre, not a single line of reason. If reasons were insufficient, we could have appreciated. These are not reasons. It is the further case of the plaintiff that the defendant has. It's plaintiff's case, defendant's case, and then the court says, now the question arises as to whether it can be granted and rejects it.
Lordship,
Without
on
answering the question. Sorry.
Just to answer on, there is one line which clearly mentioned at 103, page number 103.
Refer to the internal pages. We have the memo with us.
So
it's
it's
the last page or
last
second
page. Yeah,
yes.
it says petition order so and so order
39.7. Yes.
That the major paragraph which says, on the other hand, the plaintiff has filed an objection to said petition where it is admitted that the crane was installed, but it is not working due to fault of the defendant is as much as LR rail installation and alignment is not good, and it requires rectification and the said job is beyond the order of the defendant. Admittedly, crane is not working, and therefore it clearly says, I do not find any requirement for appointing of learned commissioner for inspection of the same. Hence, petition is rejected. So here he has also provided his opinion. The lower court has clearly says, I do not find any requirement.
That is for the purpose of 39.7, Mr. Sapre. It's very obvious.
Yes,
We cannot borrow that logic for the other application. 39.7 and 39.1 and 2 are different considerations entirely.
Right, Lordship. But narration, of course, Lordship, narration and everything has been put on
We are
record.
not going into the merits, but some reason had to be given. This order cannot stand. We are setting aside this order and remanding it to the trial court. This is not an order at all.
So
for a fresh consideration on the merits, you will be entitled to argue if you want.
For fresh hearing, Lordship?
Definitely. We are not granting mandatory. How can we grant mandatory? The trial court did not, we cannot. We cannot usurp the jurisdiction of the trial court. You are right on that, if you wanted to argue. In view of the scope of the appeal and the application being coextensive and the ambit of the appeal itself being very short, we take up the appeal along with the application for hearing. First up, learned counsel for the appellant argues that the learned trial judge, without assigning any reason whatsoever, dismiss the mandatory temporary injunction application of the appellant. First up, next para. In brief, the plaintiff/respondent filed a money suit against the defendant/appellant, and the defendant also filed a counterclaim, also for a relief, for a monetary relief. Full stop. The case arises out of transactions between the parties whereby the plaintiff had supplied equipment to the appellant and apparently agreed to commissioning of the said equipment. Full stop. Next para. At the outset, comma, we find, no, sorry, before that. Learned counsel appearing for the appellant submits that the order being palpably without reasons, comma, ought to be set aside. So next para. Learned counsel appearing for the plaintiff respondent, contends that the prayer for mandatory injunction is palpably barred by the concerned provisions of this specific relief act, comma, since the counterclaim itself is for a monetary relief and patently, comma, relief of the plaintiff, comma, relief of the defendant appellant, comma, if any, comma, lies in damages. Full stop. Hence, comma, the prayer for mandatory injunction being barred by law at the outset, comma, was rightly set aside, rightly rejected by the learned trial judge. Full stop. Next para. Although there is substance in the contention of the respondent, comma, we are unable to convince ourselves that the impugned order should be sustained. Full stop. We could have appreciated even if there was a semblance of reasoning in the impugned order for rejection of the mandatory temporary injunction application of the appellant by the trial court. Full stop. In such case, comma, it is trite law that the appellate court can also supply additional reasons, comma, if it agrees with the conclusion. Full stop. However, comma, it is equally well settled that reason is the soul of an order. Full stop. In the impugned order, comma, we find merely that the learned trial judge put in a narrative of the respective cases of the parties and thereafter in a single sentence, comma, recorded that now the question comes whether any mandatory temporary injunction can be passed at this stage. Full stop. Surprisingly, comma, however, comma, not a single line of reason follows thereafter, and the learned trial judge goes on to observe that therefore, comma, the petition under Order 39 Rules 1 and 2 of the CPC stands rejected on contest but without any cost. Full stop. Next para. The expression double inverted, therefore, double inverted clause is a misnomer and not worth the name. Full stop. The reasoning being absent, comma, the expression therefore does not connect with the previous portion of the order, comma, the concluding portion. Full stop. Since the impugned order is utterly bereft of a single line of reasoning, comma, we find that the same cannot be sustained in the eye of law. Full stop. Accordingly, FMAT 25 of 2025 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 32 dated December 12, 2024, passed by the learned judge, 5th bench City Civil Court at Calcutta in money suit number 313 of 2021, and remanding the temporary mandatory injunction application to the learned trial judge for a fresh adjudication on merits and upon attributing reasons. Full stop. Next para. It is expected that the learned trial judge shall redecide the said application in terms of the above direction at the earliest, comma, preferably within 1 month from the date of communication of this order to the learned trial judge. Full stop. Next para. We further clarify that we have not entered into the merits of the respective contentions of the parties, and it will be open to the learned trial judge to adjudicate the said application on its own merits without being influenced in any manner by any of the observations made herein. Full stop. We further make it clear that we have not touched the portion of the impugned order whereby the application under Order 39 Rule 7 of the Code of Civil Procedure was rejected, comma, since the same is not the subject matter of the appeal, comma, leaving it open to the appellant to challenge the same in an appropriately constituted revisional application, comma, if the appellant so deems fit. No address to cause, urgent certificates. Thank you, Mr. Sapre. We'll argue.
Always privileged to appear before Lordship.
Thank you. And to you also, thank you. Prothome, affidavit of service filed to be kept on record. That will be the first line. Thank you.
I'm grateful.
Next.
Madam.
14 yes.
I'm 14, my lord. I am for the appellant petitioner, my lord. The day before yesterday, my lord, your lords kindly go through the order, my lord.
None appeared despite service.
Yes.
Have you got a place? Proper
But
place
yes,
for a
my lord,
child?
I am giving one address, my lord. That is, my lord, the about 12 kilometers away from the residence of the, my lord, the opposite party, my lord. And that is the
What is the
children's
age of
park.
the child? It's a son.
Son. And
age,
my lord, the 11 plus. And now, my lord, my lord, two questions, my lord, address. One is, my lord, the right of vegetation, and second is, my lord, the proper education of the child. But now, my lord, he's not getting the proper education. Though, my lord, he has been admitted, my lord, in a school, my lord, in class 5. But my lord, he is not sent to school every day because, my lord, the absence of the mother. But the mother, my lord, the opposite party works in, my lord, in a nursing home. That is, my lord, about 25 kilometers away from her residence.
That will be decided in your main appeal because the appeal is against refusal of your custody application.
Of course, my lord, on
You
appeal,
cannot
so
decide
far
on
the
that
vegetation is concerned, my lord.
Visitation will
Yes.
immediately grant.
Yes.
Give us this address.
Kindly, my lord,
Why to type it on a piece of paper? We could keep it on record. No. It is 3 kilometers from the place of workplace of the mother. That does not mean anything. The mother will have to go home and bring the child from the home to the place. So distance from her workplace, if you want to visit the mother, your wife, then we can grant that. That will be within 3 kilometers.
Well, so far, no, my lord, so far
you don't want to visit your wife, you want to visit your child. He will have to be brought from the home. So what is the relevance of this workplace distance?
No, my lord, so far the distance is concerned. The mother will bring the, my lord, child, my lord.
But 12 kilometers is too far off.
But no, not too far, my lord, because my lord, she, my lord, works in a nursing home, my lord, that is 25
She
kilometers.
works in a nursing home. She will go back home and she'll bring the child and take him to 12 kilometers away.
No, my lord, that is why, my lord, I am giving the date, my lord.
Are you paying her alimony?
No, my lord, there is no alimony, my lord. She has not paid for alimony or nothing, my lord.
She works, that's why. But the child's expenses you have to pay.
My lord, I have tried
to bear the entire conveyance charges.
My lord, I have tried to find out the place, my lord, not available, my lord, to my lord. That is the whole difficulty.
What is not available?
My lord, the difficulty, my lord, my residence, my lord, is away from the, my lord, 30 kilometers away, at least 30 kilometers away from my lord, the house of my wife.
Where is the DLSA located? How far from her house?
That is, my lord, the 15 kilometers. DLS office. And that was the direction of by the, my lord, the Nagaland trial court.
DLSA অফিস থেকে প্রপার প্লেস হবে বাচ্চারই আমরা রিপিটেডলি হোল্ড করি যে একটা কনজিনিয়াল হতে হবে বাবা
My DLA, so far the DLA office is concerned, my lord, she has not raised any objection, my lord, before the London trial court.
The question, we are not thinking of her or you. We are thinking of the child.
Child.
11-year-old child going to the DLSA office where so many litigants will be coming, people will be coming who want to, acid attack victims may come for compensation. Is it a proper place? It's a workplace sort of.
That
Not
is
a
why
proper
I
place
have
for a
given the address of
11-year-old
the
child to.
That is why I have given the address of the children park.
Children park is good.
Yes. Nowadays, 12 kilometers, everywhere is Toto is available, auto is available, nothing, 12 kilometers. Nowadays, 12 kilometers.
Do you know the distance between your house and the court?
Pardon?
Do you know the distance between your house and the court?
Well, that is the 14 kilometers.
Where do you come from? From Basdurani you come.
Basdurani.
How do you come?
Well, by metro.
Now, this is metro available there. She'll have to take either.
Of course, no.
One single auto will not go so far a distance. Generally, in those places, Totos may, but that will cost her some considerable amount.
Yes. Well, I'll pay the cost to the wife, my lord.
Very well.
I'll pay the cost.
You will have to travel to go to that place 30 kilometers.
The 25 kilometers.
You'll have to travel.
Yes,
25.
of course. About 25, more than 25 kilometers.
There is no divorce suit. Go to the wife's place and visit the child.
But she is not coming, my lord. I am not.
You go to the wife's place
and
go to the wife's place for the purpose of visitation.
My pleadings, my lord. That is the whole difficulty.
Which paragraph?
Kindly see, my lord, the paragraph.
Show us the worst allegation against her.
Yes.
Show us the worst allegation against her.
Yes. But the
Oh, acha. Yes,
para
we have,
1-4.
we have seen.
Para 1-4.
Despite service, none appears for the respondent at the time of call. Full stop. Next para. The appeal arises out of the refusal of the appellant father's prayer for custody and visitation, guardianship and custody of his minor son of 11 years, who is residing with the respondent mother at present. Full stop. We find from the application, comma, which is uncontroverted since the respondent chooses not to appear, comma, that allegations regarding an illicit relationship of the mother find place therein. Full stop. Next para. Even without going into the veracity of such allegations, comma, we do not find it proper to direct the appellant, comma, particularly in view of the strained relationship between the parties, although there is no matrimonial suit pending between them, comma, to visit the respondent's house for the purpose of visiting his child. Full stop. On the last occasion, comma, we had requested the learned advocate for the appellant to take instruction as to a place congenial to the well-being of conducive to well-being of a child for the purpose of visitation. Full stop. Upon such instruction, comma, learned counsel for the appellant submits that there is a children's park at Gholai, Gholai, comma, Balichok, comma, police station Debra, comma, district Paschim Medinipur, which is the nearest such place from the house of the respondent mother, where the child resides. Full stop. On query of court, comma, learned counsel for the appellant submits that the distance between the said place and the house of the respondent is about 12 kilometers. Full stop. Next para. In the absence of any alternative suggestion, comma, since the respondent is consistently desisting from appearing before us, comma, we direct the respondent to produce the minor son of the parties, who is aged about 11 years. What is the name of the son?
The Swarnodip Bera. Swarnodip Bera.
Namely Swarnadeep, Swarnadeep, Bera. Produce the child, bolam to. Every Sunday between 5 and 6 p.m. at the aforesaid venue, aforesaid children's park, for the purpose of visitation by the appellant father. Full stop. The costs of the to and fro journey between the residence of the respondent with the child and the place of visitation shall be borne by the appellant. Full stop. Such costs for each of the occasions of visitation shall be paid by the appellant to the respondent on the at the time of visitation itself. Full stop. Next para. The parties shall act on the server copy of this order without insisting upon prior production of a certified copy thereof. Full stop. However, comma, as regards the other prayer of the appellant, comma, for change of the school of the minor child, comma, we are of the opinion that such drastic step cannot be taken at the interim stage, and a decision thereon can be taken only at the final hearing of the appeal. Full stop. Can 1 of 2025 is disposed of in the light of the above observations without any order as to cost. Full stop. The handwritten instruction of the learned advocate for the appellant regarding the venue of visitation filed in court today be made a part of the record.
One more thing, the direct had to leave my son for 2 hours for free missing and the love and affection.
For the time being, let it be 5 to 6 every Saturday, every Sunday.
No, for 2 hours Sunday.
For character line, the first of such visitations shall take place on June 22, 2025. 1 hour for the time.
Sunday, my lord, for 1 hour, my lord, or 2 hours, my lord, so
Sunday will be Sunday for you.
Sunday,
SON.
every Sunday, my lord, for 2 hours for free mixing with my son, my lord.
Free
Only
mixing will be
visitation,
difficult.
my lord, are not.
Let the differences between you be the child, because the child is not with you for a long time.
But for 1 hour, my lord, for 1 hour, my lord, kindly.
For the time being 1 hour.
For 1 hour.
1 hour.
Yes, my lord, kindly record it, my lord.
আরেকটা লাইন অ্যাড করে দিন যে during the period of visitation, comma, the respondent wife shall abstain, shall keep herself at a distance and permit free mixing between the appellant and his son.
For 1 hour.
1 hour, we have already fixed the hour, 5 to 6.
Yes.
Item number 15, my lord, I appear on behalf of the plaintiff.
There is a creation for affidavit, my lord, the opposition, my lord.
We have disposed of the application, they're not appearing.
So far the application is disposed of, my lord, the other prayer, my lord. So far the other prayer is concerned, my lord, the education of the child and the admission in the other.
That will be decided at the time of hearing, we have said, of the appeal. Should we direct you to put in the trial court, bring the trial court records in the other directions?
But kindly, my lord,
Mr. Ghosh, give us half a minute and please give us half a minute, we will complete the previous one. The appellant shall put in postal costs and other requisites for service of notice of the appeal on the respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
My lord, one more, my lord, the opposite respondent, my lord, will act upon the server copy of the order, my lord, because my lord, I shall, my lord, communicate the order to her.
That is the 4th line we have dictated.
Item number 15, my lord, defendants of the appellant, your lordship. My lord.
Mr. Ghosh, please take the mic. You are in any event you are soft spoken, and on the mic you are more soft spoken.
Well, I tell you, lordship, the plaintiff number 1 files the suit for declaration of title and injunction, stating that the execution of document in favor of the defendants were tainted by.
Mr. Ghosh, please take the microphone.
Tainted
Plaintiff is the respondent, number 1.
Well, it was tainted by fraud. It took a point, they were executed.
Suit was decreed.
Suit was decreed. My lord, we preferred an appeal challenging the order of decreeing the suit in favor of the plaintiff on the condition, my lord, the suit is not maintainable because the plaintiff being an executant and filed a suit for declaration. He has to file a suit for cancellation of the deed.
Only declaration was filed.
The cancellation of deed without paying advance court fees, the suit was not maintainable. Your lordship accepted my submission and lordship is to pass an order of injunction restricting the opposite party not to transfer and alienate. My lord, now the after service the matter came up for hearing before the lordship.
Yes, what do you say?
But your lordship kindly takes up internal page 13 of the order judgment. The plaintiff's case was that he did not execute the deed. That was his case. And my lord, it has been.
That was his case, but you have sought for a declaration that the deed is not.
My lord, your lordship.
The suit is not maintainable.
The court has come.
You have to file a suit for cancellation of the deed.
My lord, I am taking.
Specifically provides for that.
Section 31.
I am relying on a judgment of a division bench of our court reported in my lord, AIR 81 Calcutta 189.
This judgment,
my lord, last page, para 18. In the instant case, have your lordship find?
1 minute.
In the instant case, we have found that the plain assertion plainly is that she was given to understand that a power of attorney was being done and she lent her signature on such representation. Therefore, in law, there was no valid execution. But I have challenged in my case, there is no valid execution by me. But if I will take your lordship to that. There was no valid execution. The mind of the applicant not having accompanied her signature. Such a case, if proved, in my case it has been proved also, if proved, would render the deed void. In this case, the misrepresentation is both as regards the contents as well as regards the character of the document. And as such, the transaction is wholly void. In such a suit, it is not necessary to seek a relief of setting aside the document, and no consequential relief is implicit in relief asked for.
This is palpably contrary to section 31 of the specific
Kindly
effect.
seize the judgment.
Please come to section 31. This is
Doc-
section 31.
No, well, this is Supreme Court judgment, paragraph 6. Kindly.
No, cite it formally.
2006.
Cite it formally, Mr.
But anyway, I'm not standing in the way, my lord. It will have to be heard by your lordship, the appeal is.
Paragraph
Step
6,
in.
Your Lordship.
You have only one copy. You should have brought 2 copies for my learned brother also.
Sorry, my lord, I got the.
Citation taken.
Yeah, 2010 Supreme Court, my lord. I'm very sorry, my lord. I could. My lord, my judgments were misplaced for my brief.
Page.
2807. Well, this is with regard to the payment of ad valorem courts with in respect of Punjab Act. And the court came to a finding, my lord, the Supreme Court, in case of a executant that wants to avoid a sale, my lord, he has to file a cancellation of the deed.
Is it 6 paragraph 6? That is settled law.
Yes, yes.
Settled
That is,
law.
I didn't want to place it before your lordship, your lordship knows.
And section 31 of the specific relief act is specifically that.
AI 81 Calcutta 189. 81 Calcutta 189.
We are extending the injunction till disposal of the appeal. There is an arguable question. The question which has cropped up for consideration in the present injunction application is whether the suit filed by the plaintiff stroke respondent number 1 was maintainable, in view of no separate decree for cancellation of the impugned transfer deed in favor of the appellant was sought. Full stop. Next para, learned counsel appearing for the respondent number 1 cites a coordinate bench judgment of this court in such and such matter reported at AIR 1981 Cal 189. Naam tek to diye deben Megna. 189 in support of the proposition that where in law there is no valid execution, the mind of the applicant not having accompanied her signature, the deed is rendered void for the misrepresentation, and in such a suit it is not necessary to seek a relief of setting aside the document, and no consequential relief is implicit in the relief asked for. Full stop. Next para. On the other hand, learned counsel appearing for the appellant cites AIR 2010 Supreme Court 2807 ব্র্যাকেটের নামগুলো একটু দিয়ে দেবেন, for the proposition that where an executant of a deed challenges the same on the ground that it is void, a decree for cancellation has to be sought, whereas in case a non-executant seeks a similar relief and for relief that the document is not binding on him, a decree for such declaration may be maintainable. Full stop. Next para. We are of the opinion that a strong prima facie case has been made out by the appellant, since the plaintiff stroke respondent number 1 has challenged a deed where the said respondent was a party. Full stop. Next para. Moreover, section 31 of the Specific Relief Act 1963 clearly provides that any person against whom a written instrument is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable. Semicolon, and the court may, in its discretion, so adjudge it and order it to be delivered up at and cancelled. Full stop. Next para. Hence, there is a hence, in view of a prima facie case having been made out, as well as the balance of convenience and inconvenience being in favor of grant of injunction, we are of the opinion that the ad interim injunction granted earlier should be made absolute. Full stop. Accordingly, can 1 of 2025 is allowed on contest against the respondent number 1, thereby restraining the plaintiff stroke respondent number 1 and his men and agents by an order of injunction from changing the nature and character of the suit property, as well as for transferring, alienating, and or encumbering the suit property in favor of third party in any manner till disposal of the appeal. Full stop. In view of no relief having been sought in the appeal against the other respondents, service of notice on the other respondents, we are dispensing with service, is dispensed with. Full stop. Next para. Since the respondent number 1 is represented through his learned advocate, service on the said respondent is dispensed with as well. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
But again, I am praying for the apology, my lord. Only one copy I could.
No, it's all right. We are keeping your copy because it's not a book.
I'm grateful.
Thank you.
I beg to appear for the respondent.
Yes. Have you asked him why he did not appear in the previous matter?
No, he was engaged in another court. আরে আগের মামলাটা জুনিয়র সঙ্গে কথা
I have missed the matter, my lord. Frankly speaking, I missed the matter. Actually, I depend upon machine. Machine has missed, therefore I have also.
We have passed some order.
Yes,
No
I have
order.
Regarding Vokalatama, there is some.
Yes, yes. Vokalatama that. Number 2.
Yes.
Yes, Mr. Mato, what is this matter?
An application for substitution. Different respondent number 13 and 14 have died. One has died, my lord, during pendency of the suit.
Respondent number 13 only.
And my lord,
There are 2 applications.
14 also. One application, my lord, composite prayer.
My lord, we have taken out an application CAN 3 of 2025. My lord, this is in the nature of Order 39 Rule 4. My lord, we seek to raise construction. My lord.
So first we have to allow this substitution.
Yes.
Substitution is filed within time, Mr. Mato?
My lord, it is arising out of partition suit. Therefore, there is no question of abatement. One, well, so far respondent number 13 is concerned, my lord, he has died on November 2, 2020. Therefore, my lord,
My lord, they were not contesting in the trial court, and the learned trial court by the impugned judgment of Order 14 Rule 2 has been allowed. On a preliminary issue, that Waqf tribunal has jurisdiction.
Therefore, the substitution
And we are the
application-
primarily the contesting
CAN
parties.
2 of 2025 is an application for substitution of the heirs and legal representatives of deceased respondent numbers 13 and 14. Full stop. Although the application has been filed beyond the limitation period for filing substitution applications, we accept the contention of the appellant that in a partition suit, since the cause of action is of a continuing nature, a substitution application is virtually akin to one for addition of parties. Full stop. Accordingly, we condone the delay in filing the present application and set aside the abatement. Full stop. CAN 2 of 2025 is accordingly allowed by directing substitution of the heirs and legal representatives of the deceased respondent numbers 13 and 14 as respondents in the present appeal in terms of the prayers made in Can 2 of 2025. First of no orders to cost. The office shall carry out the necessary corrections to the cause title of the memorandum of appeal accordingly within a fortnight from date. What is Can 3?
Yes,
For
Can 3.
application for injunction Can 1, there is a direction to file affidavit in reply. This is my affidavit in reply.
Opposition you have filed?
Yes, yes, we have.
And what is Can 3?
Application
What is Can 3?
Can 3 is, my lord, we are
for permission to complete this first floor construction.
in the nature of Order 39, Rule 4, my lords. My lord,
yes, what do you say to that?
My lord, the dispute of encroachment is in the suit. It has been pleaded.
True, but they have already what is the level of
I tell your lordship, my lord. But first,
So, my lord, what is my submission, my lord? It is against the decree dismissing the suit on maintenance ground that it is not maintainable before the civil court. It is required to be filed before the tribunal, walk-up tribunal, because it is a cooperative. My lord, kindly fix the matter tomorrow or my lord Thursday week. Matter may be discussed.
No, we don't have any other work. Tomorrow we'll fix it and hear it out.
Well, it is very short point at the time of
All the matters are short point. Mr. Mathu, we have understood our different meaning of short points.
Admittedly, it is walk-up property, and when it is partition suit.
What will be your answer to that, Mr. Banerjee?
my lord, my answer to that, my lord, it's admittedly a walk of property, and we have challenged the muttawaliship of the plaintiff. My lord, since we have challenged the muttawaliship in our written statement, my lord, in terms of the judgment of Rashid Ali, my lord, of the Honorable
Should go
Supreme
before
Court,
the walk of
it
tribunal.
has to be before the walk of tribunal. One. And number two, my lord, during the interregnum, post the dismissal of the suit, my lord, we got a period of 6 months. That is from December 18 to April 2025. My lord, during this time, my lord, we have raised a substantial construction in the second floor, in the first floor. My lord.
No, Mr. Mahato, regarding walk of tribunal, what do you submit?
My lord, would kindly takes our written statement.
It shouldn't go before the walk of tribunal.
No.
Because there is no question involved for decision, adjudication, whether it's.
Whether it is a partition, only for partition. Whether I am.
No, we will decide only the applications now. The
My lord,
applicant-
would kindly take.
Kindly permit me to file opposition.
Very well.
But then kindly fixes a date of hearing for this Can 3, my lord, of this order.
Can 3 along with 2, along with 1.
Yes.
Along with 1. The appellant shall file written affidavit. The appellants shall file their affidavit in opposition to Can 3 of 2025 within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Full stop. The reply filed in respect of Can 1 of 2025 today be kept on record. Full stop. Next para. The Can 1 of 2025 shall be listed along with Can 3 of 2025 to be heard together on July 15, 2025.
My lord, instead of July 15, my lord, any day, my lord.
July 16?
Yes.
July 16? July 16.
This is my appeal, will it?
Yes.
May I have my lord's leave to file the affidavit of service split? With a caveat was
Several
there.
defects. Let us find out
Yes.
the defects first.
But,
Deficit code fee you have to put in.
we have put in, on 11th April 2025, there was a deficit code fee of 24 rupees filed, Millard. But I have the
Yes, deficit code fee has been put in. That is also stated here.
Yes.
Other defects. One is erroneous classification of appeal by word. That also you have corrected,
yes, that was corrected on that day itself.
but there is no endorsement to that way. Let us see the others. Certified copy of the certified copy of the decree on appeal, wrongly classified decree in original suit. That will have to go to the trial court, appellate court. Surname of the sole respondent in certified copy does not tally with that in the certified copy of. Not your problem.
Well, this, but I was intimated by the
These will have to go. The certified copies will have to go to the trial court.
No, I was intimated that they will send it to the trial court themselves, and accordingly corrections would be made.
That was to be done. We will direct that to be done. But in the meantime, let us hear the application.
Yes, sir. No,
What is the decree for?
The first appeal, the first appeal was allowing the suit, which was dismissed by the trial court. It was a suit for eviction, Millard, on the ground of building, rebuilding, and reasonable requirement. The trial court held.
No, who was the you are the plaintiff.
No, minute. I am the defendant there. The plaintiff had filed an appeal, had filed a suit for eviction.
Dismissed.
Dismissed.
That was only on the ground of reasonable requirement.
No, minute. Dismissed on the ground that the
No, the suit was on the ground of reasonable requirement and
building rebuilding
And also
default in payment of rent.
Reasonable requirement, default and
Building rebuilding.
building rebuilding. It was dismissed. Appeal court reversed on which ground?
On the ground that the
Building rebuilding.
No, minute. The reason for dismissal by the trial court was that the notice under section 12 it had wrong details of the scheduled property, and so was in the plaint. On that ground, the trial court held that since the very basis of a eviction suit being the scheduled property being wrongly stated in the plaint as well as in the notice, therefore the suit is not maintainable and therefore dismiss the
There are
suit.
contrary judgments, several judgments.
There are conflicting
Defect
judgments.
in notice. Both of you know which property is being referred to. Address is correct.
Yes.
Particulars wrong. Error in
No,
particulars.
here the particulars were with regards to the number of rooms.
That does not vitiate the notice.
Also,
You know which rooms you are
the
occupying.
basis on which the first appeal court had allowed the decree and the judgment relied upon by them, those were different facts and circumstances.
No, what is your substantial question of law?
So for me,
Appeal court reversed and granted degree on what ground?
on upholding the trial court's observation of building rebuilding being in their favor and the reasonable requirement also being in
But
their
then
favor.
it's a concurrent finding regarding building rebuilding, and so then where is the scope of interference?
No, the basis of there was no cross appeal, which should have been there. There was no cross appeal being filed, or neither any but cross objection was taken at the time of argument, which is allowed. Now, the trial court, while dealing with this, while passing a judgment, they had misread the evidence. And I did not get a scope before the first appeal court to place those evidences, the evidences, and not get that observation
Settled.
overturned.
Mixed question. We cannot, second appellate court cannot reappreciate evidence.
But the evidence is, it is only about the evidence is already there. Evidence has been recorded. I'm only inviting the court to have a look at the evidence to see as to whether
Cannot.
the evidence, the difficulty being that the only ground which was agitated, and also the amendment of the plaint was allowed before the appeal court.
Incorporating what?
Sorry,
Incorporating what? Their current requirement.
the correct schedule. Despite that being agitated by us before the trial court, no steps were taken for amendment, and the amendment was only made after the trial court, after the appeal court granted them liberty, and then the appeal, thereafter.
No substantial question of law involved. No question of law involved at all.
We'll kindly appreciate this. The ground of rebuilding and building by their own evidence, by the plaintiff's evidence only, is not maintainable.
Well,
and so for rebuilding and building. On the play, I will not even invite my lords to look into the evidence of the defendant.
courts must have discussed the evidence.
No, my lord.
No.
The evidence was not discussed. Not discussed, only said. We'll kindly have a look at the.
We'll come back and continue.
Very well.
Yes, please. Let us see how the trial court dealt with all this.
Minute, first of all, minute, I will want to first say this minute. A schedule in the plaint is important minute, in this context. Why? Because minute, basis the schedule, the ground of reasonable requirement will be furthered. Minute. We will kindly have a look at the trial court's the decree, which we will find at page 55 of the stay application. Can 1 minute. The relevant portion will start from page 61, where the issue number 4, which was, is the plaintiff entitled to get the relief as prayed for, has been dealt with. Page 61 minute.
Yes, 61.
61 minute, I will skip the first few lines, which is with regards to 7172, and let's straight away come to page 62, first paragraph, last 5 lines. Minute.
Right.
Or should I read the entire one? I think it's better to have continuity. In this suit, page 61 onwards, in this suit, plaintiff and defendant both have admitted their relationship as landlord and tenant, but the defendant has challenged the scheduled premises as vague. Defendant in a written statement has stated.
No, this is page 62.
Page 61, I am reading the last paragraph at page 61. The last paragraph, only to ensure.
Yes, in this suit, right.
The defendant has challenged the scheduled premises as vague. Defendant in a written statement has stated the defendant is a tenant in respect of one room measuring 15 by 8 in the ground floor. Whereas, as per the plain scheduled premises, suit premises consisting of one shop, one pakka room in the ground floor of Barkat building. Learned advocate, the defendant draws the attention of the court to Exhibit 5, which is the notice to quit, dated 14/11/2014 to the defendant by learned advocate the plaintiff. It appears the schedule of the said notice to quit the eviction room has been sought for by the plaintiff from one shop room, one go down, and one pakka room in the ground floor of Barkat building. It appears that during cross-examination, PW1, the plaintiff himself is the defendant is tenant in respect of one room. From the evidence of DW1, the defendant, it appears that defendant is tenant in respect of one shop room under the name of Manoj Stores under the plaintiff. Thus, admittedly, defendant is tenant of one shop room. Therefore, from the evidence of both the sides, this reveals the defendant is tenant under the plaintiff in respect of one shop room from where she runs the business. Then it goes on to say with regards to why the scheduled property is important to be correct. Then we will kindly come to page 63. With the second paragraph at page 63, it appears that
yes,
in the schedule of the plain, the ejectment of the defendant has been sought from one shop room, one pakka room in the ground floor. Therefore, it reveals as per the schedule of the plain that there are two rooms, one of which is a shop and the other is a pakka room from where the plaintiff is seeking ejectment of the defendant. Learned advocates, the plaintiff submitted during the argument such description should be read as conjunctive and not as disjunctive. But from careful reading of the plaint, it appears that the plaintiff has put one punctuation mark in comma after one shop and thereafter stated one pakka room, which clearly depicts a picture of the suit premises consisting of two rooms. The comma in between one shop and one pakka room denotes the existence of two rooms, which is contradicted by PW1 during his evidence, as PW1 unequivocally admitted during cross-examination the defendant is a tenant in respect of one room. Besides this, PW1 has stated clearly during cross-examination that the plain schedule is not fully correct and he will rectify the same. Thus, it appears that the plaintiff had knowledge of the incorrectness of the schedule but has not amended the same in spite of having the scope for the same. What has come from the evidence of both the sides regarding description of suit premises does not corroborate the schedule of the plaintiff. Such being the position in the schedule of the plaintiff remains as disproved being inaccurate, and if a decree is passed on such schedule, it will be inexecutable. Therefore, considering all facts and circumstances and taking into account the evidences that has been culled out on record, I do hold that no relief can be passed in favor of the plaintiff on the basis of the schedule so appended with the plaintiff. Now, my lord, another 2 points on the basis of which the plaintiff has sought for ejectment of the defendant are reasonable requirement and building rebuilding. Plaintiff in the plaint has stated that as the family members are increasing day by day and as such, he reasonably requires the same. From the evidence of DW1, it appears that DW1 has stated during cross-examination that plaintiff has one young son, namely Javed Akhtar. DW1 further states that I do not know whether Javed Akhtar is an employed person or not. DW1 also states that I do not know whether Javed Akhtar has any business or not. DW2 during cross-examination says that I do not know what job the plaintiff's son is doing at present. 2 years ago, the son of the plaintiff is working as a manager at Ilex Cinema at Galaxy Mall situated at Burnpur. Thus, it appears that none of the defendant's witness could state the exact occupation of the son of the plaintiff. For reasonable requirement, what I am required to, sorry, they have also failed, they have failed to state that the son of the plaintiff is employed or not. Further, DW1 has stated during cross-examination that Mohammed Qayyum is a service holder at Kolkata, but I do not see where he works, do not know where he works. I have not seen Mohammed Qayyum going and returning from office. On the other hand, has stated that plaintiff has a business. Therefore, it appears that the testimony of DW1 is based on surmise and conjecture surmise in respect of occupation of plaintiff, which cannot be relied on evidence, as the version of DW's regarding occupation are contradictory to each other. But the first defendant is a widow, and the second defendant, the second witness, was the son of the widow. Thus, it appears that the third witness was not the son-in-law of the widow. Thus, it appears that the plaintiff has been able to prove his contention of reasonable requirement, and the defendant is able to disprove the same. But what has been proved, what has been stated on evidence is that plaintiff has got only one son. The son was working somewhere. And the plaintiff himself is also working.
The requirement is for what?
For whom?
No, as per the plaintiff case, what is the requirement
As for the plaintiff case, the plaintiff is saying that we are many brothers. We are 4 or 5 brothers, and it was an unpartitioned property, and we being having our separate families. Not there is a requirement.
This shop room is exclusively owned by the plaintiff.
In a partition, the plaintiff has received. But what is important is that it's a 3-storied building.
So therefore, he wants to run a business from there. His son, for the business of his son.
He has not mentioned that in the plaint. Nothing has been mentioned. In fact, in his testimony, what has come forward is that the building has 3 stories, and there are 12 tenants. Apart from this person, this defendant itself, there has been no eviction suit filed against anyone else.
He need not. He can choose a tenant out of the.
For building, rebuilding, if I have to bring down the entire building, I have to proceed for eviction against all the tenants. Only then will I be able to rebuild. But that evidence has come in, and that has not been considered. Now, I'll take my lord to the next page also, page 65. Plaintiff is also sought for ejectment on the ground of building rebuilding. Also, DW1 during cross-examination has stated that the premises are very old building. Yes, sir, it's a very old building. DW2 has stated that the suit room is situated in an old building, and I have been seeing this from my birth. He is all of 20 years, Lord. Thus, it appears that DWs in the testimony have corroborated plaintiff's contention regarding damage condition. No, Millard. This contention was not corroborated of the building, as we have stated that the suit building is an old one. Thus, it appears that the contention of the building for plaintiff for building and rebuilding is established and the same is proved. Now, I will kindly come to the last paragraph before issue number 5. Thus, I've almost reached towards the end of my discussion. On the discussion of the preceding paragraph, it appears the plaintiff has been able to prove his contention regarding ejectment of the defendant on the ground of reasonable requirement and building rebuilding. But the schedule of the plaint remains inaccurate and is contradicted by the plaintiff in his evidence. Description is mentioned in the schedule property has not been corroborated by the testimony of the plaintiff himself and the DW1 and 2. Then he says that since it's only one room and therefore considering all, the plaintiff has not been able to prove any case. And according to the instant issues decided in the negative.
What is the appeal court judgment? You have an example.
Now, the appeal court judgment will start from page 81. The appeal court has, in the initial pages, set out the contentions of the parties in the trial and formed after page 85 onwards.
Page? Which page?
85. I am relying upon from the CAN application. Page 85 onwards, decision. The formulated by the appeal court were whether the impugned judgment and decree suffer from any material irregularity. This was a point formulated, and whether the trial court was right in dismissing the suit. But then the main issue which was there that no, I will be failing my duty if I do not point out that it has been recorded that no objection was filed. Then we'll see paragraph 12. Having heard both sides and on perusal of record, it appears that the plaintiff has filed the suit for eviction and tenancy of reasonable requirement as well as violation of condition by the tenant in respect of tenanted premises. The violation of condition by the tenant, though not a ground here, While deciding issues so framed by the trial judge, issue number 1, 2, 3 has been decided in favor of the plaintiff. While deciding issues 1, 2, 3, the trial court judge has observed the suit is maintainable, cause of action is there, and not barred by any relief specific provision of law. No cross objection is filed by the respondent before this appellate court in respect of the observation of trial judge while deciding the above issues in affirmative. So, with regards to
Will admit the appeal.
yes, thanks for that.
The present second appeal will be heard on the following substantial questions of law. Whether both the courts below substantially erred in law in arriving at the conclusion that the suit premises is required by the plaintiff respondent for the purpose of building and rebuilding, comma, merely on the basis of the admission that the building is old, comma, without adverting to relevant materials as to whether the building was really in such a damaged condition that building and rebuilding would be necessary in the first place. Roman 2, whether both the courts below substantially erred in law in holding that the plaintiff respondent requires the suit premises for their own use and occupation, comma, without coming to any specific finding as to the present accommodation of the plaintiffs, comma, the number of family members of the plaintiffs, comma, and or any quantification of the actual requirement of the plaintiff stroke respondents. Next, whether both the courts below committed a substantial error of law. Now, whether the learned judge of the first appellate court committed a substantial error of law in reversing the findings of the learned trial judge to the effect that the description of the suit property was erroneous, comma, in view of the description not pertaining to the mere particulars of the suit property, but also hitting at the root of the total number of rooms available and in respect of the entire nature and character of the suit premises. Yes, any stay application you have filed?
Yes, Milord. Can 1 is my stay application.
You'll file your opposition. You'll disclose the occupation charges. Have you levied execution?
No, Milord. Not.
Not
I am
yet.
not aware of. No, because we had served upon them. They filed a caveat. No,
You have already served. Very well. Can 1 of 2025 is an application for stay of operation of the impugned judgment and degree of the courts below, which of since we have already admitted the appeal on substantial questions of law, comma, a strong prima facie case for hearing the appeal on merits has already been made out, which of even otherwise, comma, in view of the impending danger of eviction, comma, sufficient urgency as well as irreparable injury, as well as apprehension of irreparable injury has been made out. Full stop, the balance of convenience and inconvenience is also in favor of grant of the stay as prayed for. Full stop, accordingly, the operation of the impugned judgments and decrees of both the courts below, the impugned judgment and decree of the first appellate court shall remain stayed till disposal of the application. Full stop, next para, the appellant, the respondent shall file affidavit in opposition to the stay application within how much?
2 weeks, madam.
Within a fortnight from date, comma, disclosing particulars and annexing materials, comma, if any, to assess the occupation current market rent in the area. Full stop, reply if any thereto shall be filed by the appellant within 1 week thereafter. Full stop, liberty to the parties to mention the application for being listed before the appropriate learned single judge having determination after the above timeline is over. Full stop, it is made clear that the question as to whether occupation charges should be imposed for the as a condition for grant of stay, and comma, if so, comma, the quantum of the same, comma, is kept open for being decided at the final hearing of the application. Thank you.
I'm deeply.
You have argued very well. You have changed our mind.
I'm
Yes.
sorry. Thank you, Milord.
Yes.
I'm grateful, Milord. But it's a pleasure to argue, Milord, in such courts where, Milord, the juniors are getting enough indulgence.
You are not
from
so
the-
junior. That does not apply to you.
I will always remain to be a junior, Milord.
Yes. 18, yes. Yes.
I am for the appellant, my lord.
Court is favorable only to juniors, so you don't have a case. What is the second? This is the second appeal.
Second appeal, my lord. I have ground number, my lord, 1, 2. I place ground number 1.
Give us the facts, basic facts.
My lord, the basic facts is, my lord, the appellant before your lordship was the plaintiff in one suit, and the defendant filed another suit. Both the suits have been heard analogously, and the order has been passed analogously.
You are the plaintiff in what was the relief claimed in your suit?
My suit, my declaration of title, interest over the suit property.
And what was their suit?
Which I have inherited and we have purchased. And
Some
another
portion you have inherited, some portion you have purchased.
But inherited portions has not been detected in this both the suit and appeal. And my suit has been dismissed.
No, what was their suit for?
Suit for declaration.
Other side suit?
Other side suit for declaration of for cancellation of deeds and declaration of title.
So both courts held against you.
Both the courts held against me, dismissed the suit. Inherited property is also not detected.
What do you show us from the appellate court judgment or something?
My lord.
No, why was the deeds? Why were the deeds cancelled?
Deed cancels, my lord. The deed was made. One portion of the there are two owners. One is Divakar Pal, another is Ramapada Pal.
Right.
Divakar Pal died. Divakar Pal's property has been inherited by my clients, my lord, but by the plaintiffs. But the Ramapada Pal, given an orphanama, give his shares to son and two grandson. One son and two grandson. The son sold me. Who was the witness of the orphanama? Sold me.
Why was it set aside by the trial court?
Trial court that said that there is an orphanama in respect of Deti property, so it is set aside.
But if there is already an orphanama, it could not have been transferred to you subsequently.
But my inherited property, that is also dismissed.
There is no finding on that inherited property.
No finding. No, neither by the trial court nor by the appeal court. Kindly see. My lord, it is admitted in that is, my lord, in second page of the judgment, page number 3. There is in middle portion, Ramapada Pal signed as witness in this way, plaintiffs inherited the share of Divakar Pal and purchased the share of Ramapada Pal. My inheritance is already in there, but that has not been stated in decision.
So this is a Devottar property. You are Shevaites.
No, in one property we have inherited. Another property I have purchased, which has been given to orphanama by Ramapada Pal, to whom he sold me.
Can you please show us from your plaint? Have you got a copy of the plaint? That
my lord, I mistake it.
The portion where you have claimed that you have inherited some of the property?
My lord,
Yes, that is reflected from the trial court judgment itself. Trial court judgment says that your plaint case has been narrated.
Appeal court also said.
Yes, yes.
So, my lord, I am paying admission in respect of 1 and 2.
That ground that regarding the inheritance, the courts have not considered that portion.
1 and 2. That I have stated in 1, 2, and 6. 6 another ground.
Why so many grounds? Then more the number of grounds in a second appeal, the more chances of dismissal. 1, 2, and 6.
My lord.
1 is
1, 2 are same.
1 is general.
2 and 3 are same.
2 whether both the courts will. We'll make it precise. We'll make it one. The present appeal will be heard on the following substantial question of law: whether both the courts below substantially erred in law in proceeding to pass a decree. Achha, one thing, you have filed only one appeal.
But 2 appeal.
2 appeals. Both are appearing.
Next appeal is
acha.
19.
তাহলে 18, 19 দুটো একসঙ্গে
Sorry, my lord, I'll show petition passed.
18 19 দুটো রেখে দিন। হ্যাঁ, তুমি তাহলে এক কাজ করো, দুটো অ্যাপিল একসঙ্গে করে দাও। The present second appeals are shall be heard on the following substantial questions of law. One, whether both the courts below substantially erred in law in failing to declare the title of the appellants, at least in respect of the portion of the suit property which is inherited by them, comma, without adverting to such aspect of the matter and proceeding entirely on the premise that the portion of the property which were claimed to have devolved upon the appellants through certain deeds were vitiated due to cancellation of the said deeds. Acha, any interim order you have prayed? Can
My lord,
one?
my lord.
What is the nature of the injunction?
My lord, paragraph 9, my lord, I am in possession. Page 9.
আচ্ছা, আরেকটা লাইন অ্যাড করে দাও তারপরে both the appeals, comma, arising out of analogous suits, comma, shall be heard together. Next, can one? Yes, since a prima facie case has been made out and the balance of convenience and inconvenience is in favor of grant of injunction, comma, the respondents stroke opposite parties and not their men and agents shall be restrained by an order of injunction from interfering with the peaceful possession and enjoyment of the appellant stroke petitioners over the suit property till disposal of the application. Full stop. The appellant shall serve copies of the application on the respondents, indicating that the same shall next be listed before the appropriate learned single judge having determination. Full stop. Affidavit in opposition, if any, shall be filed by the respondents within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Liberty to the parties to mention the application for inclusion in the list of the learned single judge having determination after the above timeline is over. Full stop. The appellant shall file an affidavit of service before the learned single judge at the time of final hearing of the injunction application.
Highly obliged.
ডিফেক্ট আছে দেখে নিয়ে একবার। Mr. Banerjee, you are appearing?
Lord, I am the caveator.
Caveator.
I was giving a notice that the matter was mentioned before your lordship. Matter will appear on 16/6/2025. This is the notice, my lord.
No, 16/6 we have already crossed.
Yes, this is the notice.
No, keep it, please. No copy of the application was given.
Yes, copy of the application.
First, let us check up what is the defect.
Lord, oh yes,
defect. Anyway, none is appearing. We will adjourn for the day. Let us see if they repeat this absence, then we will consider. None appears for the appellant at the time of call, although the respondent is represented by the learned senior advocate appearing for the respondent. Full stop. Next para. Let the matter stand adjourned for the day. শুধু ওনাদের নামটা রেকর্ড
দিয়ে দিচ্ছি।
Yes, Mr.
21, yes, my lord. I am appealing for the plaintiff appellant, my lord. This is a suit for eviction, my lord, for a judgment of reversal.
Don't laugh. That does not mean automatically that you we were taught to be more give a more scrutiny, more serious scrutiny to reversals. Yes.
The suit for eviction on the ground of reasonable requirement, nuisance, and my lord, the 2G point was also.
You are the tenant.
No, I am for the landlord.
Ah.
For the landlord.
You had a degree on which of the grounds?
Well, I have obtained a degree on the ground of 2G. On the ground of 2G.
2G.
Well, at that point of time, well, Pilani Properties was there, well, on the basis of only copy pasted. Well, I should be very candid, well, the trial court has decreed in favor of me. Well, after that, when they approached the appeal court, Rajesh Mitra came into existence. And the
then you don't have a case now.
Yes, well, my case is, well, only one single point, well, I'll take before lordship, well, my case is that, well, original tenant was Renuka. And, well, I have issued rent received in favor of Renuka. Since 2000, in the year 2011, when she died, my lord, for the first time, my lord, all other legal heirs, my lord, have deposited the rent before the rent controller and they have made an application. Their defense case is that, my lord, they are claiming tenancy from their father since 1976. Well, I was a transferee landlord. My case is that fresh tenancy, my lord, created in favor of Renuka. But to this extent, my lord, no rent release has been issued in favor of them to show that, my lord, at least after they have attained majority, my lord, they have taken any steps to, my lord, before the any forum, my lord, that I am the tenant, we are all the tenants in common.
Not. Once there is a tenancy, you have to show that it's terminated.
Well, my case is that my
Continues,
entire
the
plain
tenancy
case is that, my lord, Renuka is the original tenant, nothing. My and my lord,
They are the heirs of Renuka.
Renuka heirs, my lord, but not they have came into only, my lord, before the court in 2011, not before that. My lord, they what, my lord, my case is on a very single point, my lord. My
It was a suit filed.
Suit filed in the year 2016.
2016. So then, at the time of death of Renuka, they were there.
Yes, they were there.
So they are heirs under the original definition.
Yes, my lord. Your lordship.
Tell us this. The trial court dismissed the suit only on
No, not dismissed.
decreed the suit on which of the grounds?
Only on the ground of 2G, but I have taken a reasonable requirement and nuisance. The trial court came into the finding as when a 2G is there.
Oh, trial court did not decide on the other points.
No, not decided.
The appeal court also went only on 2G.
Only on 2G. Entire.
So that itself probably is a substantial question of that. The other questions ought to have been. No. Show us that the other questions were not dealt with.
Yes. My lordship will kindly take, my lord, first.
Just because you are saying you are nodding, so that the appeal is admitted.
My trial court's order, lordship will kindly take first, my lord.
And Mr. Shamanto has not gone into the judge. Mr. Shamanto, have you gone through the judgment of both the courts below? The other points have not been decided, not been dealt with.
My lordship will kindly take the judgment of trial court, my lord. It starts.
You find out for yourself whether the other points were dealt with.
Well, I have taken a look. My lordship can definitely.
We will go by your whatever it is.
Page 90.
Page 2 to 19. If your lordship sees, yes. Last page 19. All.
As a
Yes. Well, as a cumulative result of the findings on issues of 1, 2, 3, 4, the defendants are held to be trespassers in respect of the suit premises, and as the initiation of proceeding for eviction itself is enough to bring to the notice of trespassers that the eviction is sought for, the plaintiffs are found entitled to relief as sought in the plaint.
The present appeal will be heard on the following substantial question of law, whether both the courts below substantially erred in law in not deciding on merits the eviction suit of the appellant, plaintiff stroke appellant. What are the other grounds taken? Reasonable
requirement and nuisance.
On the grounds of reasonable requirement and nuisance, merely by adverting to the ground of that the defendant stroke respondent was 1 to 3 had been rendered trespassers by operation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997, although the eviction suit was filed on the said other grounds as well. Next para, whether the courts below substantially erred in law in failing to adhere to the mandate of Order 14 Rule 2 of the Code of Civil Procedure, in terms of which the courts are duty bound to decide, adjudicate on all issues involved, irrespective of the fact that the suit may be decided on only one of the issues. Yes, injunction restraining them from transferring.
But not to create any disturbance, nuisance, because I have already annexed a copy of GD.
Since the prima facie case has been made out, the respondents opposite parties shall remain and or their main and agent shall remain restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in any manner in favor of third parties till disposal of the present application. Nuisance we are not granting. Nuisance was not.
Only I have made a paragraph at page,
What nuisance?
Nuisance, my case was that they used to disturb me. They used to block the ingress and egress, resulting in the death of the plaintiff's father. He was.
Since we cannot implement, that's a big.
Very well. I have only lodged a complaint prima facie to show before this court. My lord, that page 13, my lord. Lordship and my lord, there is only a
No,
GP,
only
my
this,
lord.
only this. Till disposal of the application, first of the appellant shall serve copies of the application on the defendant stroke respondent numbers 1 to 3, indicating that the application shall next be listed before the appropriate learned single judge having determination after the timelines for filing affidavits are over, full stop. The respondent numbers 1 to 3 shall file their affidavit in opposition, comma, if any, comma, to the present application within 3 weeks from date. Reply, if any, shall be filed within a week thereafter, full stop. The appellant shall file an affidavit of service to that effect at the time of hearing of the injunction application, final hearing of the injunction application. Full stop. Service on the respondent number 4, comma, who was a co-plaintiff with the appellant in the trial court, comma, is dispensed with.
Grateful, man. Grateful.
অ্যাপিল কোর্ট যদি পুঁজিতে ঘুরিয়ে দিত তাহলে রিমান্ড করা উচিত ছিল ট্রায়াল কোর্টে বাকি গ্রাউন্ড। Yes.
But I was not there yesterday.
But you are there now, Mr. Basu is not. Mr. Nag is there.
What is? Mr. Nag is.
Basu is on his legs. Well, may I place the original certified copy of the impure
What
order?
is the appeal about? Just tell us that. Oh, so original certified copy was not filed.
No, it was filed without on the basis of the server copy. Upon leave
During the vacation, it was filed, I believe.
একটা লাইন লিখে নাও অন্য কিছুর আগে যে the original certified copy of the impugned order filed today be kept on record and be tagged with the memorandum of appeal. Full stop. Yes. What is the matter?
This appeal is against an order passed in an injunction application. The injunction application has been disposed of. There was an injunction application as well as the vacating application filed on behalf of the appellant defendants. Both were taken up together and disposed of by a common order. Now the issue is,
what is the suit for?
Suit for declaration and injunction.
Declaration of title.
Tenancy right.
Declaration of their tenancy right.
Yes.
Very
now
well.
the issue is, it's a.
There is no eviction counterclaim.
No.
Very well.
The defendants are the unit holders. Are the unit holders of the same building, and the.
Oh, you are not the landlord.
No. We are the some of the unit holders of this building, and so far as the plaintiff respondent is concerned, is claiming to be a tenant in respect of the roof.
Only the roof.
Only the roof. And on the basis of a document which was executed.
You reside on the roof.
There are rooms there.
There are no rooms.
There are rooms.
There are no rooms. There's no rooms. There's common right over the
We thought you were a telephone tower.
Now my access to the roof has been cut virtually.
Pardon, we can't hear you. Mr. Minang, take the microphone a bit closer to you. There's a disruption in this.
My access to the roof has now been curtailed in view of the injunction application. Injunction order.
What is the exact injunction obtained by them?
Not to. Okay.
No. Plaintiff has claimed that they are the tenants of the roof. And you reside where? Which floor? You also reside on the roof?
No. We have an office over there.
You're confusing between the roof and the other rooms.
No. We have our independent office spaces in the on the other floors of the building.
So you can cut off their entry to their roof. How can the roof owner cut off your entry to your portion?
That is how it has been done.
What is the injunction granted? Is he confusing the facts?
No, but it is not. I'll tell you the chip.
He was dependent on Mr. Basu. He did not.
Yes.
No. Kindly cease.
He has read up to the roof, but below that he has not gone below that.
No. Kindly cease.
Helicopter paragraph only.
The original, the ad interim order which was initially granted, that has been now confirmed.
What is the injunction or exact injunction granted?
546.
We have the certificate copy.
No,
you have to file another copy of the certificate copy.
Yes.
The brotherhood we have here. So
sorry.
246 is the ad interim order, which was confirmed in the final order.
So it was merely confirmed. Without
no,
any
it is
further
a detailed order, but the last ordering portion is I'm confirming that interim.
It's no difficult.
Yes, so that order it records that possession of the plaintiff of the suit property ad interim or temporary injunction from a status quo. As on date, nature, character, and possession.
No. Ad interim order you have annexed here anywhere.
Yes, page 246. That's in the page 2. Volume 2. ওটা পড়লে বোঝা যাচ্ছে না। যাই হোক পরে আবার অন্য পাল্টে যাই পাল্টান 246 ঠিকই বলেছি তো হ্যাঁ ঠিকই বলেছি
Nature, character, position, yes.
Yeah. Now kindly see the plain. Kindly see the plain is at page 37.
What is your allegation in the plaint? What sort of nuisance disturbance they create?
Allegation is I am the lessee in the property in the roof.
Obstructing you.
Yes, obstructing me and using it. Now, my lord, the defendants who are named here, these three persons or the four persons are the office bearers of is the multi-storied building in off Park Street. They are the office bearers of the association of the property who is maintaining the property. From day one, I am saying if they have a right of maintenance. They can't claim ownership of any inch of the property. The association can only have a right of maintenance.
So, Mr. Let us hear complete.
Yes.
Now,
yes, Mr. Nag, what is the question of you being affected? Suit property is only the roof portion.
Right.
So they have obtained an order of status quo regarding nature and character of that portion, regarding which they have an unregistered lease, and also regarding possession of that portion.
Now,
so how does it affect you at all?
Because we are the unit holders of the same building having a access to the roof.
Achha.
Now that right has been curtailed. It's not. But learned friend is saying that he has sued me only in the capacity of the association. It's not correct because we are the unit holders also of the same building. Kindly see my objection that I have filed.
You have roof rights also.
Yes. Now kindly see the schedule of the property, like the shoot property at page 42.
Yes, we are looking at that only. The area has
entirety of the roof space.
Ah.
Now kindly see the praise. A declaration that the defendant have no right, title, and interest in respect of the suit schedule property. Injunction restraining the defendant number 1 and 4 and their agents from committing any nuisance disturbance in peaceful possession of the plaintiff over the suit property. Now, my main question, the main question which was agitated, that the basis on the document on the basis of which the plaintiff is claiming right over the roof has been executed in violation of an order of injunction subsisting as on date in a pending suit before this Honorable High Court. Now your losses.
That lease was given in respect of the entire property, scheduled property.
Yes.
And what is the basis of your right? Any document?
Yes, that I have annexed.
Your roof rights. Let us see your roof rights.
My vacating, kindly consider my vacating application, which is at page 82.
Yes. 82. Where are your deeds? I mean, unit. Unit means you own particular flats.
Yes, office.
Areas.
Yes. A flat. Well, para 15 that I have mentioned in para 15 of my vacating application at page 92.
Yes.
এগুলো কি এগুলো কি Now my deed starts from page 204, which is annexure C that I have mentioned in para 15.
The pages remind us of the sky outside, complete with clouds and all.
So old document,
particularly page 207. 207 is probably a
is the backside of that.
Yes. Right. Anyway, the reverse pages have also been given. That's why that.
Yes, that's one thing. Now my flat, the description of my
roof.
The description of my property, my flat is schedule B at page 229.
Where is the roof right? Proportionate share is something else. Staircase, common passages, other common areas.
Yes.
Roof is not specifically mentioned.
Their
deed was prior to yours. Their deed was executed prior to yours.
No.
Your deed was prior.
Yes. Much before.
How do you know that they were the common rights included the roof rights?
Well, the common rights include the roof because the the losses not unless
Even if not mentioned, my lord, roof right cannot be segregated. If a person is in the property, his right is in the roof recognized under the statute.
Which statute?
Calcutta Municipal Corporation rules.
Show us the rules.
Yes.
If I am sold a garage space, I get a right on the roof.
Yes, my lord.
If I get a garage space, only purchase a garage space, I have a right on the roof also.
My lord, I will not argue with my lord. I will show the rules. 117 sub rule 4. Yes. I have to say, my lord. 170.
কি বই এটা? KMC building rules.
117 sub rule 4.
Sub rule 4.
থাকবে না ঘরে থাকবে না।
Context
Probably my lord's notice, recently, my lord, the corporation, I was appearing in that matter, stop all the rooftop restaurant.
Yes.
Why? Reason is,
This.
reason is, why it has been stopped? Reason is, the building is occupied by the different persons.
They cannot have access.
When the roof is occupied by a single restaurant, none has an access.
I didn't know this.
I must be candid. There is a judgment delivered by the division bench, where the division bench said that yes, this is statutory right, but you, with conscious mind, you can forego the right. So I should not be allowed.
Statutory right, can you forego?
That is the division bench said that you consciously you can forego, consciously. কি বলেছিস আমি কোনটা দেখব একটা সেকেন্ড থার্ড প্যারাগ্রাফটা দেখেছিস না বাস ঠিক আছে
There is a scope of stay of the interim order. Will admit the appeal and direct the appeal and the application to be heard.
Here, my lord,
You are asking for stay.
I have to, my lord, that HON'BLE will not apply. It is a case, is a straight violation. Apart from that, what is the prima facie case? His lease is in the teeth of an interim order passed by a competent court of law. He is pleading, my lord, paragraph 3. Kindly see what is his pleading of the plaintiff. I am reading for my lord. The brief facts of the matter is that the plaintiff entered into a lease of tenancy of the entirety of the roof space, not such and such, on 15th April 2024. Can you mark the date? Justice Kumar has basically got it. 15th April 2024. I'll come to page 38.
38.
On that date, if duly instituted suit between the lessor of my London Friends client, there is a specific injunction not to transfer and alienate anything. That I also, my lord, page kota bolto ota?
Advice that is an irregular transfer, but he is not bound by that injunction.
It says void. The Supreme Court said it is void. And my lord, can you recall those judgments where there is a clause on sale, agreement for sale also, my lord, has been classified as an honest.
Where have you annexed the injunction order, Mr. Basu?
My lord?
Where have you annexed that injunction order? Have you?
Yes. My lord, page 145. There shall be an interim order restraining defendant number 1 and 2 from creating any third party interest in respect of the properties in respect of which the suit has been filed. That is on 5th April 1994. The plaintiffs are also restrained from dealing with or disposing of any of the properties which are the subject matter of the suit without the leave of the court.
And you have stated that that is subsisting.
Subsisting till today. And my lord, I
Have they stated from whom they have taken the lease?
Yes.
Where have they stated?
Must be from the lessor. That has not been said. They become the lessee.
No, they've annexed the deed. Let us see that deed. Deed annexed at page 53.
Page 53.
It's from someone else. MA Leasing and Construction. They are not a party to the suit.
No. Maybe, but what from they are getting, that is also void because of the injunction.
Neither the lessor nor the lessee are bound by the injunction order. They are not parties to that suit.
No, lessor must be bound. No, not this lessor. The person from whom this MA leasing is getting it. But a property is sub judice. And in that suit, a property, what is the language there? Language is not to be deal with the property.
Yes, the respondents therein were Ahin Chaudhary and some those people. Sorry, Jogeshwari Mullik and
Yes.
those people.
But they are getting lease from the original lessor who is the party in the suit.
Is it narrated in the deed? Let us see in the lease deed. It has to be explicit.
I am sure this is not there. What? 434. Visa deal is there. You can get some hints here.
Part of that such and such. Accepting small portions in the north block already let out or transferred to one Sardha plywood. A demise favor of leasing. So their lessor also got it on in 1995, which is after the injunction order.
Yes, that I'm saying. That is also Lordship can get their pro forma dependent also file an affidavit. There they have a chain they have said.
And they say they got it from one Bijan Bihari Mullik.
Yes.
So
Original lessor.
Mullik's must be, yes.
এটা আমাদের, this is our team. ছাড়বে না এই যে got it. But 444 না কত এটা?
17.4 is common access. Does not mean right to use the roof. Every terrace on the topmost floor, that is obvious.
That cannot be.
That is obvious because if there is an emergency, people may have to go there.
Yes. That's why the rules.
But the injunction status quo granted is their position on that property and the nature character cannot be changed. You cannot disturb their position.
None of his prayer.
Not disturbing your access also, in fact.
I'm going to little add. Interim order should be in aid of his final relief.
Yes.
What is his final relief? That exclusive right in the root.
Yes.
It is granted. In the teeth of the rules, apart from this malad injunction or their right to the property.
It's an arguable question. Every terrace shall have a common access.
Right.
Common access does not necessarily mean it cannot be transferred to somebody particular.
Even if transfer or exclusive transfer cannot be given, kindly once read malad the rules.
17.4.
Subsection 4, it cannot be parted with. Reason is malad, it is not a rule malad bear. There is a reason behind it for framing the rules.
Common access is different from not being transferred. Common access because of emergency reasons.
Can you visualize? Common access, staircase is clear. But the moment I enter the roof, this exclusive right, I cannot enter. It is malad, cannot be any logic behind this. I got the access, the moment I reach the roof, I have prevented.
Very well.
And can you be sure of this? Be sure of this injunction, my lord.
And what about this? Mr. Nag was arguing that you also have rights to the roof previously, apart from 117.4.
common area and facilities. A building, my lord, when a particular person is purchasing a.
It's not specific regarding the roofs.
Sometimes it may, sometimes it may not.
We don't know whether the roof was retained by the.
My lord, there may be a right to construct, but whenever, as soon as this is constructed, I have the access to the roof of the ultimate construction.
What is his judgment about cited?
This is, my lord, on the basis of. My lord, this is 2013, 14 Supreme Court cases, 6, 8, 9, paragraphs 9 and 13. May I read with your lordship? There cannot be any quarrel with the proposition of law laid down in such and such that a suit is deemed to have been filed on the date.
Yes.
Of the date of presentation of the plaint before the competent court, but the same does not have any bearing on the question relating to the legality of sale deed dated 9/11/1973 executed by Bhubaneswar Kanti during the currency of an order of injunction passed by the London Municip on 6th May 1971. It is not in dispute that as on 9th November 1917, the date on which the said deed was executed, the order of injunction passed by the trial court in suit was operative. It is also not in dispute that the order of injunction remained effective till 1976, when the plaint was returned for the presentation before the competent court. In other words, till the refiling of the plaint, the order of injunction passed the London Municip, restraining the defendant from alienating the suit property, was in force, and Bhubaneswar Kanti could not have executed the sale deed in favor of the respondent herein. Now kindly come to paragraph 13. After quoting our section 23, court is saying, in each of these cases, the consideration or object of an agreement is unlawful, and every agreement executed with such an object or consideration which is unlawful is void. Since the sale deed was executed in favor of the respondent number 1 in the teeth of the order of injunction passed by the trial court, the same appears to be unlawful.
Here the parties themselves had transferred. In your case, you have to establish a chain between them.
Yes.
Because this person was.
Affidavit also is on record before the court.
What do they say?
They
purchased from Gauri Mollik. Who had
500
1, 2, and 3 there? Gauri Mollik and others.
No, 500 কত জানা বললে? 523 kindly come once.
We'll continue after the recess, Mr.
Kindly excuse me after the recess. That is, if it is now, I am.
No. We'll continue after the recess. We are in the midst of the hearing.
So, my lord has seen the plenty is.
Plaint of the that suit for the injunction. No,
I have also asked for
the parties that would be very crucial here. Jyotirmoy Mollik and all. 100?
Yes, that is it.
Which page?
104. Yes. What's that point, owners?
Yes.
So, jury about limited. Even number 2, Bijon Bihari Mollik. Apartment Private Limited.
Yes.
Apartment Private Limited.
Yes, yes. And they say that
The deed are annexed. I am showing you.
no, in the deed they also say that they have obtained from Bijon Bihari Mollik also.
That is there. Madam, kindly come to page.
Yes.
Kota?
Page 55, read with 105.
Yes, my lord has read that.
No, I just now.
I repeat, my lord, his injunction should be in aid of the suit. Apart from that, they have no right, but they are asking for a declaration of a decree which is cannot be performed, cannot be given, my lord, in the teeth of the rules. There cannot be any exclusive right of the roof. With the fact, my lord, there is a judgment. I am not relying, they may rely. That yes, the statutory right you can convey, you have to convey it expressly knowing that you are foregoing your legal right.
That is not here.
That is not here. I anticipate my lord argument, that's why I make that argument.
So very well, let us hear them then. Yes, Mr. Mitra.
Well, the first issue is, I am a lessee in respect of the roof. A registered lease deed is in my favor.
Unregistered.
Registered. I'll show you the lease deed, madam. The first registered lease deed which is in my favor is at page 523, which is in favor of the MA leasing. MA leasing.
Not yours, your predecessors.
I'm a party to the suit. MA leasing is a party to the suit in city civil court, a pro forma defense.
Where the injunction was passed.
Yes. MA is a party to the suit. I'm a party. I appeared. This document was brought on record.
You are different. You are a different person. You are Sudip Langya. You are claiming through MA whatever.
No, I am the plaintiff is my lessee. Is my lessee, Kanchan Jyoti. The plaintiff is my lessee under me.
What opposite party? Respondent.
Yes, yes.
Not.
Who is the main respondent? Kanchan Jyoti Rao.
Yes, he is the main respondent.
But my right is coming from him.
You are Kanchan Jyoti Rao.
No, he is Kanchan Jyoti.
He is my lesser.
He has to defend.
This injunction is who is the plaintiff in the suit?
I am the plaintiff.
He is the plaintiff.
So that he has to defend his own case.
No, I will just say it in because we sail in the same boat. I may say because she is my lessee.
You cannot make out a case for her. Your rights, she's claiming through you. The plaintiff has to. Very well. The plaintiff claims through you.
Yes. Plaintiff claims to me.
Yes. You are bound by the injunction order.
I'll tell you, Lordship. So in the year 1995, a registered deed was executed in favor of MA leasing, which the deed is at page 523 in respect of the entirety of the roof with a right to sublease. That lease is there. On the strength of that deed, today I have executed this unregistered lease in favor of Kanchan Jyoti. She is in possession. Now, so far the roof is concerned, there are 2 points of defense is taken, Malad. One is the roof is a common area, and the second is this has been executed in the teeth of order of injunction.
And 117.4.
117. Now, first is there are agreements in connection with this property which they have disclosed where the roof right is exclusively excluded. I have annexed it here. It's annexed.
From their rights?
Yes. Now she will kindly come to page 505. This is a agreement of 1984 of Jorat Investment. Jorat Investment is a
500?
496. Jorat Investment. 113 Jorat Investment. Yeah. Jorat, this is a deed in favor of 496. In favor,
496?
yes, in favor of one Jorat Investment. This deed, Lordship will kindly see first, then page 504. 504 records, it is first para. It is, however, the purchase, if, however, the purchaser requires car parking space, it's a cluster, first clause. The vendor shall allot in the basement or any side of the ground floor covered, uncovered car parking on the fresh terms and condition. Next manner, clause 14. The vendor, however, will be entitled to construct additional floors and or other constructions in the open space compound roof of premises 113 Park Street.
Without affecting the ingress and egress.
Without affecting, yes, without affecting the ingress and egress. Now the main page 505. 505, it records the first 505, the first,
yes,
the second line. The purchaser will have no right in respect of the roof and terrace of the building. So they have a right of ingress egress. I had made a specific submission before the learned civil court that so far the ingress egress is concerned, for maintenance of the roof, I am not stopping.
You cannot restrict it to
I cannot.
Maintenance. You cannot restrict it to maintenance. They can anytime go and come and go. Ingress and egress as per
Ingress and egress. I bow down to your lordship.
Then how can there be a status quo regarding possession?
I am in possession. They have a right of ingress and egress. By walking into the roof does not mean they have a right of ingress and egress. No further right on
that
the
violates the status quo regarding possession.
No, but so far
to that extent you are agreeable.
To that extent I'm agreeing. To that extent I'm agreeing that they have a right of ingress and egress. Now,
all right.
So this is one point. Second is, they say that the roof is a common area under 117 of the building rules, which cannot be today sold or done anything with the roof. There I have twofold answers. First is the document by which MA Leasing gets the right is of the year 1995. Is much prior to the current rules coming into force. 1995, my deed. The 1995 deed, which I have showed to your lordship, which is at page, the registered deed, page 523.
All right.
Yeah, this is by which the entire roof comes to me. 5 is a much prior document than the present rule of 2009.
All right.
Now, so a portion of the roof, and now lordship will see, what did I get? The schedule is at 534. No, 534. Yes, the 534. What did I get? 534. The entirety of the roof. Sorry, man.
Yes.
All that, the entirety of the roof of the north and the south block containing an admeasuring of an area of such and such square feet.
This is a suit property. You have described as this.
Yes. Now, there is a catch manner here.
Except small portion.
Yes.
That is also part of the suit schedule, plain schedule.
So, this 150 square feet of the roof is not given to me. So, there is 150 square feet. Now, the question I'll answer goes to whom? This 150 square feet goes to...
You have pleaded to some supply or someone.
Yes, that is the different number one's company. That is the appellant before the court.
So they also have a right to the
yes.
The more.
They have given the right. So the roof is not common to everybody. He has purchased 150 square feet. Annex the deed. We will now come to the deed. This deed is at page 489. 4 is the continuation of the deed. Sorry, Malan. I have just come to the first page. Is at 475. This is purchased by Sharda, and this Chitlangia is the main person in control of Sharda Plywood.
He's a director or what?
We know is Chitlangia's companies like that. Whatever. Now this deed is once again between Jogeshwari and all those persons, my lord. This deed now kindly come to 489. The first para, after the 6 or 7 line, there gets a parking space, and also all that space measuring 150 square feet on the northeast side of the roof. So for him, the roof becomes his exclusive property, and the schedule contains that. The schedule is at page 494. So he, by a separate deed, this Mr. Chitlangia, by name of his company, purchases a portion of the roof. So that portion can't be common anymore. He was the owner by the deeds of conveyance. Today, my lord, and so one deed says no right to the roof. Ingress, egress. To that extent, I have to give them a right. Today, my lord, this deed, and I have a right of sublet and all these things. I have a right. Now I come back to the point of the subsisting order of injunction, which they say I have violated. Now, this subsisting order of injunction, which is placed before your lordship, is at page 145, which is a 1994.
Yes.
1994.
Yes.
My deed is after that, 1995. For all these 30 years, parties were aware of this document. I am in possession of the rest is open space. 2 or 3 rooms are there. Even the 150 square feet is there on the roof. So I am in possession of 2, 3 rooms and the open space. For last 30 years, this situation is going on. There is no complaint of a contempt. If I have violated an order of court, a contemptuous violation, and it has been violated by the Maliks along with me, has to be because I am the purchaser. So there must be a contempt filed. There are proceedings in furtherance to that violation. This is number one argument. Second is, I don't say it's violation because she will now see who are the plaintiffs. The plaintiff is the Poddar Point Owners Association. In the suit, the plaintiff is annexed. The association says that what happened, this building was constructed off the partially the 10-story building. After construction, because there are many proceedings going on, the developer evaporated practically. He entered an agreement for sale, evaporated. So there was a huge chaos in the property. So this suit for management was filed by this association. So who will manage the property? There are hundreds of orders passed by this court by which officer of this court was appointed, army colonel was appointed to manage the property for maintenance, collection of rent, and maintenance charges, and clean sewerage and everything. So it is that suit. Now this suit says interest in respect of the portion is in respect of the properties of which the suit has been filed. May I come back?
Yes, yes.
Page 145, Ashish Pal's order
Yes,
record.
yes, we have seen that. Yes.
Now the question which begs an answer, what is the suit property? The plaint does not contain a schedule. The plaint is here, page 113. Page 113. The plaint is at 113. Because the unit owners, the multi-story building, the unit owners have the right of their individual flats. Today there is no schedule. There is the papers which has come. We are ad hedem on this. There is no schedule to the plaint. Now the order says suit premises. The plaint, there is no schedule to the premises. So these are the things that this has to go for trial. This point, they have an ingress egress from day one. We considered. I cannot stop it because by that time the fire, the rooftop restaurants came in. I am aware of these things. I cannot then put the life to a risk. I'm not at all. Now they can't claim more than that. They can't claim more than that. So this plaint does not contain a schedule. So without a schedule, you read the order, one-line order, that status quo, but has to be clear. So on this, I say these things has to go to trial. Now today, in the ad interim order of injunction and we have annexed these documents before the court, and they have a right of maintenance. Now this plaint. Now Lordship will kindly come to the plaint. Plaint is, Lordship will see the plaint. Kanchan Jyoti, page 13. Page 37. Sorry, 37. Kanchan Jyoti is done. Sudip Chitlangia, Santosh Kedia, Meghnad Ganguly. This Meghnad Ganguly is secretary of the association. Now, all are office occupiers situated at Poddar Point, and I am the pro forma defendant. Now, so I say that they are disturbing my possession, kindly protect my possession. In their vacating application, which they file at page 82, they describe themselves as members of the association. They come at because there may be 200 flats in the property. So they are not represent 200 people in the house. There's more than 200 units in Park Street. In Park Street, in some point of time, these properties were made in 130 Poddar Point. Yes, paragraph 7. All members of the Poddar Point Owners Association obtain possession and all this. So it runs a case of Poddar Point Owners Association. So on these facts, my lord, today I say, now Lordship will kindly come back to the order of injunction which has been passed on this, the ad interim order of injunction. Having 246, whatever, I mean, this is annexed twice. Ad interim order says that a temporary injunction in the form of status quo as on date as to the nature. I'm not constructing anything.
Nature character, we are with you.
Nature character. Now, possession. This, if Lordship clarifies, possession is already with me and also with them also, 150 square.
Ingress and egress to that.
Ingress and egress, but that will not create any equity in their favor. Ingress, egress is whatever nature, they go have a cup of coffee and sorry, Mala.
They have to pay for that. You are running a rooftop there.
I can run once a rooftop. Once it becomes a rooftop cafe in Calcutta. Be that, Mala, the lighter note, Mala. So they have an ingress, egress, will not create any equity in their favor. I cannot stand in that way. But and the ad interim order, sorry, the final order of injunction which came after affidavit, because 39(1) and 2 opposition and 39(4) were taken up together. After recording all the submissions, it records that this order was made confirmed. So it's basically goes back after all the reasonings. It basically goes back to the.
Yes, what do you say, Mr. Nag? Will dispose of the appeal itself. Will open up that ingress egress without creating any equity, as you say.
Clarify on 2-3 issues, ma'am.
Yes.
The point which was taken that the suit which we said there is.
এটা চলবে এটা ফেরত দিয়ে দিন ওনাকে মিস্টার নাগকে yes sorry continue.
The point which was taken in respect of the earlier suit which is pending before this honorable court, where we said that this is order of injunction. My learning friend taken up.
Point. Take the microphone, Mr. Nag. Yes. What is your answer to that?
There is no suit property mentioned. There is no suit property. There is no clarity about the suit property in that particular suit. Now, kindly see page 107 once. The plaint.
117.
107.
It's 107.
Yes. Para 1. The plaintiff number 1 is an association of owners and occupiers of the flats and office spaces at a multi-storied building commonly known as Poddar Point, situated at 113 Park Street.
Please come to your reliefs in the suit, that suit.
Right.
Please come to page 136.
Perspirary is order on rule 8 will leave.
Leave that. The perpetual injunction is at page
uh,
137E.
Yes, a declaration that the plaintiffs are the lawful possession or occupants of the different portions of the Poddar point.
Of the different portions, it is very vague.
No, kindly, different
You have not
portions.
pleaded that you are in occupation of the roof, apart from your portion, maybe.
No, I am not on the, I am not.
So different portions is not affected by this impugn order, present impugn order.
Now, what I am saying, the right which the
That is the
plaintiff.
violation of this injunction, the perpetual injunction at page 137. Please come to.
Right, now kindly see the note.
No, not right. Please come to prayer E.
Yes.
Next page. That is the perpetual injunction in aid of which the temporary injunction was granted.
Well, kindly sees the notice of motion.
No, first come to page 137.
Yes.
Read out your perpetual injunction.
Restraining the defendants and each of them from in any way disturbing or interfering with the peaceful use, occupation and enjoyment of their respective flats and or office spaces at the and the common amenities and facilities. Now kindly sees the injunction order, which is
Roof is not an amenity or a facility.
No, Maila, kindly see the injunction order which is subsisting till now.
That injunction is in context of these prayers.
Kindly see the notice of motion, the injunction application. This pairs of the injunction application has been mentioned in the notice of motion. Kindly see once that.
Where?
Page 152 once, madam.
Yes.
Prayer B. Injunction restraining the respondent number 1 to 6, their servants and agents from interfering, for transferring, encumbering, alienating, and or in any manner dealing with.
This has not been granted. Sorry, this was beyond even the prayer of the. This was beyond the prayer in your suit.
Now, kindly see the what was the order passed in the
Yes,
suit.
see the order, page 145. Yes, come there.
There will be an order. Page
It was
1.
a very conscious order.
There will be also an ad interim order respondent number 1 to 2 from creating any third party interest in respect of the properties in respect of which this suit has been filed.
Yes.
Page 100. That
In
is
respect
premises
of the suit, the suit has not been filed in respect of 130, entire 113. The suit is defined by its prayers in the absence of a schedule. In paragraph 1, you might have stated many things. You might have described the entire property. How does it matter? Suit is defined by the schedule, if there is any, and the prayers. Your prayers pertain to your office flats and common amenities.
This order was passed in respect.
So it does not touch the roof specifically.
In my humble submission, the suit property was premises number 113 Park Street. That is the suit property. 113 Park Street.
Sorry, cannot
Kindly
accept
see, and what was this subject matter of challenge? Because the different flat owners of the property, of the entire property, different flat, the possession of the different flat owners of the entire property was been because there was a deed executed, that deed was challenged because there was a deed executed in respect of 113 Park Street, and the challenge was that that deed was executed without there being an authority in law. So that was challenge. That was the context of the suit. That was the background on which the suit was filed. That's why this an order of injunction was passed, not to creating any third party interest during pendency, not to create any third party interest. Now that 1 to 2 has been subsequently changed to it will be abiding on not only 1 and 2 defendant number, because kindly see page 147, it will be on defendant number 3, 4, 5, 6 and 7 as well. Page 147. Initially it was only against defendant number 1 and 2. Thereafter it has been modified at page 147. In place of 1 and 2, it will be 3, 4, 5, 6, like all the defendants. Now, the suit was in respect of premises number 113 Park Street. Now, since there were a transfer happened without there being an authority, that was the background on which the suit was filed. Considering that aspect, the injunction was granted, saying that there will be no third party right further in respect of the property. So, in respect of the property means when the respect of the premises number 113 Park Street, madam. It is my humble submission. Now, kindly sees my deed on the basis of which I claim to have a right over the roof. I have that page 229, the schedule.
What was the date of your deed? '93.
Yes, 1993. Which is prior to their deed that they are referring to.
Show us that.
Page 204.
We are at 229. Please show us.
Yes, 229. Now, the schedule is a flat office space situated on the 4th floor. Northern block, being block B of the premises number 113 Park Street. More fully described within Schedule A herein above, measured with a covered area of 5,000 square feet, together with the proportionate, undivided, impartible, and indivisible part or shares of the land under the said flat and office space and or underneath the said building, and the use in common with all other occupiers of the staircases, common passages, and other common areas and parts subject to payment of the proportionate right. Now, this common space and common parts includes the roof.
But what about page 496 onwards? Please come to that deed. Whose deed is this?
On
Anandilal Poddar.
Right.
Without
Malad-
affecting the ingress and egress, other necessary facilities.
Right. So
Their vendor-
that is an office space. That is a small office, a godown, an office space which is just beside the roof. Roof is open. Just
So
beside.
page 504, Mr. Mitra, is whose deed? Their predecessor or your predecessor?
No, another deed. He is a
That is a
co-plaintiff
general-
113.
Ah, fair.
This Jorhat is a
Jorhat is,
co-plaintiff
I'm
is a
not Jorhat.
113.
That is a different. He's a different owner. Different.
So
No, but they are co-plaintiffs there
Yes.
because their injunction is circumscribed to this.
Yes, there's a co-plaintiff there.
Yes. So, Illosis knows that unless the roof right is expressly curtailed in the deed, roof right cannot. No, in my deed it has not been curtailed expressly. I have seen 229. It does not say that I have no right on the
You
roof.
have been given only the common areas without specifying whether the roof is included.
Now the
How
law,
do you know what is the common area?
common
No
area-
specific right has been given on the roof.
Kolkata Municipal Corporation Act, the another
Your deed would be subject to the previous deeds, prior deeds.
Yes.
The
Now,
prior deeds of this plaintiff's deeds, one of the co-plaintiff's deeds, this Jorhat, this deed was a prior deed, wasn't it? Prior to you.
84.
yes. Prior.
So all
Now-
these prior deeds specify clearly, they carve out a right of ingress.
Right, carved out. But so far as I am concerned, my right has not been carved out. Man, I am
You
concerned
have
with
not
my
been
right.
given any right to the roof.
Man,
Where is the question of carving out?
The common portion includes the roof as per the.
No,
Kolkata
that is your
Municipal
argument.
Man,
That's entirely not borne out by your deed. Whatever common rights were there.
Now what I am humbly saying, man, the common right includes the roof right. Includes the roof right, because under the provisions of the Kolkata Municipal Corporation Act, the roof right is a common right to all the occupiers.
Yes. Whether you decide whether you will decide the appeal or the application.
No, you Losses was suggesting something, man.
We will carve out ingress and egress. Ingress and egress will make it very clear that this does not prevent your ingress and egress, free ingress and egress to the roof. But regarding nature character, we won't disturb the interim order. And
because nature and character in all
in any event, it would be
I am not concerned with the nature because I am not.
because
I will not change.
tomorrow they may want to change the nature and character of your
So they won't be, so they are prevented because of the order of status. So they can't change the nature and character. I am not concerned. I will not change the nature and character.
No.
I need a right.
You cannot disturb their possession in respect of that property in the garb of this ingress and egress. You can go in and come out.
And this
Yes, now this
temporarily.
Now this is a situation, man. They can't claim an exclusive possession. That is my contention, man. They can't claim an exclusive possession. Now, if I go into the property, if I have a right to access, that means they don't have a exclusive possession right.
This is the order will pass. We have made our minds clear.
Yes.
We are deciding the appeal itself.
And-
It remains in the appeal.
Decide the appeal.
And Malan also kindly says how on the basis of that order of injunction, Now they are also trying to change the nature and character, like they are using it as a
File an
nursery.
injunction application.
Yeah, they
Let
are-
the appeal come to us, we'll see. The present appeal has been preferred by the defendant in a declaratory suit against an order whereby the appellant's application under Order 39 Rule 4 of the Code of Civil Procedure was dismissed, and the injunction, temporary injunction application of the plaintiff stroke respondent number 1 was allowed by making the ad interim order granted earlier absolute, to the effect that there shall be status quo with regard to nature and character and possession of the suit property, comma, which is a portion of the roof of the concerned building. Full-stop learned senior counsel appearing for the appellant argues that Rule 117 within bracket 4 of the Kolkata Municipal Corporation Building Rules 2009 prevents any subdivision of a terrace on the topmost story of any building. Full-stop, it further provides that every terrace on the topmost story of any building shall have a common access. Full-stop, it is submitted that the status quo with regard to exclusive possession of the plaintiff stroke respondent number 1 is antithetical to such provision. Full-stop, learned senior counsel next argues that the lease deed in favor of the predecessor in interest stroke lessor of the plaintiff, comma, which is a pro forma defendant stroke respondent in the present litigation, as well as the subsequent lease deed executed in favor of the plaintiff, are violative of an order of injunction passed on April 5, 1994 in suit number 113 of 1994.
April 4. April 4. 5th April.
April
Sorry,
5.
5th.
Full stop. Next para. It is contended that as such, comma, the transfer, the lease deed in favor of the plaintiff as well as its lessor are themselves void. Full stop. Learned senior counsel cites নামটা দিয়ে দেবেন, reported at 2013-14 SCC 689 in support of such proposition, comma, where it was held that a transfer in violation of an injunction order, a transfer in the teeth of an order of injunction is unlawful and is void. Full stop. Next para. Learned senior counsel appearing for the appellant further contends that the defendants also have roof rights. The defendant stroke appellant has common rights to the roof of the property. Full stop. It is submitted, comma, by placing reliance on the title deeds of the defendant appellant that the said defendant that the said deed confers right to the common areas of the suit property and the common facilities and amenities thereof. Full stop. It is argued that the roof rights come within the ambit of such common facilities. Full stop. Next para. Learned senior counsel appearing for the you are appearing for the both. Appearing for the respondent, plaintiff stroke respondent as well as the pro forma respondent contents that insofar as Rule 117 within bracket 4 is concerned, comma, the same merely confers common access to all residents of a building to the roof. Full stop. It is submitted that the respondent stroke pro forma respondent does not have any objection if temporary ingress and egress is given to the defendants with regard to the portion of the roof which is occupied by the plaintiff. Full stop. However, comma, such temporary access cannot be converted to a right to disturb the exclusive possession of the plaintiff. Full stop. It is submitted that the injunction order passed in suit number 113 of 1994 has not been violated at all by way of the lease granted in favor of the plaintiff as well as its predecessor in interest. Full stop. It is submitted that the plaint of the suit in connection with which such injunction was granted does not contain a schedule. Full stop. The rights claimed in the said suit are restricted to the respective flats and office spaces owned by the members of the plaintiff therein, that is the Poddar Point Owner and Occupiers Association. Full stop. By drawing the attention of the court to the injunction order dated April 5, 1994, comma, it is contended that the same merely restrains the defendant numbers 1 and 2 therein from creating any third party interest in respect of the properties, তারপর italic say, in respect of which the suit has been filed. Full stop. Next para. Since the suit was not filed in respect of the roof rights, comma, the same does not prevent transfer of the said rights in favor of the plaintiff or its predecessor in the present suit. Full stop. Learned senior counsel appearing for the respondent stroke pro forma respondent further argues that even in the deeds executed in favor of the plaintiffs in suit number 113 of 1994, comma, it is clearly mentioned that the rights conferred on them by the said deeds in respect of premises number 113, comma, Park Street, comma, Kolkata would not affect the ingress and egress and other necessary facilities and benefits of the purchaser. Full stop. Next para. Thus, comma, a specific portion of the roof, comma, separate from that granted to the present plaintiff and its predecessor, comma, was conveyed in favor of a company of which the present appellant is one of the controlling parties. Full stop. Next para. Thus, comma, it is submitted that common rights to the roof of the said building was never conferred in favor of the defendant stroke appellant. Full stop. Next para. Upon a careful perusal of the materials before us, comma, we find that the points argued in respect of the application are the same as those involved in the appeal, and accordingly we take up the appeal and the appeal application together for disposal. Full stop. Next para. We find from the plaint of the suit, that is suit number 113 of 1994, comma, in connection with which the injunction order dated April 5, 1994 was passed, that the same did not contain any schedule. Full stop. In paragraph number 1 thereof, comma, it was mentioned that the plaintiff number 1 was an association of owners and occupiers of flats and office spaces in a multi-storied building which was situated at 113 Park Street. Full stop. Next para. The prayers in the said suit did not pertain to the entire building situated at 113 Park Street. Full stop. The declarations sought were specifically restricted to the lawful possession and occupation of the, within double inverted, different portions of Poddar Point and the other plaintiffs in respect of their respective flats and stroke or office spaces and common amenities and facilities double inverted close, at the said building. Full stop. Next para. Hence, comma, it is absolutely not borne out by the relief sought in the said suit and or the averments made therein that specific roof rights in respect of the said building were claimed therein. Full stop. The injunction order dated April 5, 1994 was restricted to the properties in respect of which the suit had been filed. Full stop. Hence, comma, the injunction order, comma, read in conjunction with the averments made in the plaint and the reliefs sought therein, comma, make it abundantly clear that the same pertain to the respective flats and or office spaces and the vague common amenities and facilities which were not defined therein. Full stop. As such, comma, it cannot be said that there was ex facie violation of the said injunction order by transfer of a portion of the roof of the said building in favor of the plaintiff and or its predecessor. Full stop. Next para, we find from the agreement of sublease made in agreement for sublease dated April 15, 2024, executed in favor of the plaintiff by its predecessor MA Leasing and Construction Private Limited, that the same pertains to a portion of the roof of the said building. Full stop. As rightly argued on behalf of the respondent and pro forma respondent, comma, the deed by which a lease of 999 years was executed in favor of MA Leasing and Construction Private Limited was dated June 5, 1995, comma, which was much prior to coming into force of the Kolkata Municipal Corporation Building Rules 2009. Full stop. Thus, comma, in any event, comma, the purported bar under Rule 117 within bracket 4 of the said rules did not affect the transfer in favor of MA Leasing and Construction Private Limited. Full stop. Since valuable rights and vested interest in an exclusive portion of the route had already devolved upon MA Leasing Construction Private Limited prior to the coming into force of Rule 117 within bracket 4, comma, subsequent transfers by the said lessee MA Leasing and Construction Private Limited with regard to their exclusive portion of the roof cannot be said to be hit retrospectively by the 2009 rules. Full stop. Next para, even otherwise, comma, as held above, comma, it cannot be said that there was any ex facie violation of the injunction order. Full stop. Moreover, comma, even from the deeds executed in favor of the plaintiffs in suit number 113 of 1994, comma, we do not find any specific roof rights being created in their favor. Full stop. Next para, be that as it may, comma, we find from the several transfer deeds in respect of the different portions of the roof of premises number 113 Park Street, comma, Kolkata, that the said transfers carved out an exception with regard to the ingress and egress and other necessary facilities and benefits with regard to the roof. Full stop. That apart, comma, in view of the fair concession given by learned senior counsel appearing for the respondent, plaintiff respondent and the pro forma respondent MA Leasing, to the effect that they would not have any objection if for emergent reasons, comma, ingress and egress is allowed to the defendants in the present suit, comma, we are of the opinion that the impugned order can be modified stroke clarified to the said limited extent. For sub next para, insofar as the change of nature and character of the suit property is concerned, comma, in any event, comma, the subject property ought to be maintained in statu quo during pendency of the LIS, and as such, we do not intend to interfere with the said portion of the impugned order. Full stop. Next para. Accordingly, FMAT 208 of 2025 is disposed of by modifying the impugned order to the limited extent that the parties shall maintain status quo with regard to the nature and character and possession of the suit property, comma, with the rider that the defendants and the men and agents might have limited and temporary ingress and egress to the suit property for specific purposes, comma, if any. Full stop. It is made clear that such ingress and egress shall not be of such a nature as to disturb the exclusive possession of the plaintiff in respect of the suit property, and or shall not create any equity or special right in favor of the defendants. Full stop. Next para. We further clarify that we have not entered into the merits of the suit, and it will be open to the parties to raise all issues at the final hearing of the suit, and the learned trial judge shall be at liberty to proceed independently in adjudicating the suit without being influenced in any manner by any of the observations made herein above. Can such and such is can 1 of 2025 stands disposed of in the light of the above observations, no address to cost. Meghna judgment format. List chale.
I beg to appear, Millard, on behalf of the appellant. Yes. This is from Millard refuse.
This is from
Millard grant of ex parte Millard ad interim order of injunction in a suit for declaration and injunction. Declaration Millard to the effect that Millard certain loans Millard granted by the defendant bank are bad. That is Millard the declaratory relief Millard short for, and injunction Millard mandatory injunction for Millard return of Millard the documents Millard by production of which by depositing
loan granted by you
by me
to them
are
bad. They took the money.
They took the money. Mortgage the property. Millard, this is Millard only to stall SARFAESI action.
Obviously, but loan is bad. Actually, that is the
Millard,
language.
kindly see Millard the language in which Millard the.
Then they should return the money.
Kindly take Millard the plaint once.
Yes.
Millard page 20 is the plaint. Millard page 32 Millard is the prayer. 33 is the prayer.
Yes.
Millard, there are two applications. Millard, one is Millard for production of additional document, additional evidence. Kindly take Millard the stay application. Millard has seen Millard, yes. That's Millard the relief short for.
Have they alleged that you did not pay the money?
No, they did not say so. Millard, they say that Millard, some of Millard the private defendants, they Millard mortgaged the property, took the loan in their name, mortgaged the co-owned property, co-ownership property behind their back. That's Millard the allegation. My lord, kindly take Millard the cost title of the plaint. Millard, I just Millard indicate what they have Millard. Millard, the plaint starts at page Millard 20.
Yes.
Millard 1 and 2 are Millard brothers. Millard, defendant number 1, plaintiff 1 and 2 are Millard brothers.
Yes.
Boshe ponna. Defendant number 1 is Millard me. Millard, defendant number 2 is Millard plaintiff's cousin.
Yes.
Millard, the defendant number 2's father and Millard the plaintiff's father were brothers.
They are also parties.
They are also parties. Now, Millard, defendant number 3 is nephew of the plaintiffs.
So what is the
their allegation
against?
is Millard, this defendant number 3, he played a fraud.
By
Millard giving us documents, by Millard taking loan, and Millard by mortgaging property.
So they say that the loan was taken by Saurabh Ghosh.
Saurabh.
Not by the plaintiffs.
That's their case. But the loan documents are signed by the plaintiffs also. They say their signatures have been forged and manufactured.
Yes. So what injunction has been passed?
Millard, not to sell, alienate, transfer the property, not to disturb their possession. Millard, the plaint clearly refers to, my lord, the notices issued under section 13(2). Kindly, my lord, just have a look at, my lord, page 26 of, my lord, my stay application, paragraph 11 of the plaint. My lord, these are the notices, my lord, which were, and these are annexed to the plaint. These are the notices, my lord, which are issued under, my lord, Sufficiency Act.
Where the shows the 13(4) notice one.
Yes. My lord, inadvertently, my lord, the annexures to, my lord, the injunction application and the plaint are, my lord, omitted here. My lord, the
Annexures are
injunction-
there. Some annexures are there.
Some are there, my lord, some are omitted. My lord, these are, my lord, the injunction.
13(4) you have omitted.
Yes.
Great.
Kindly take, my lord, page 44 of this bunch.
44 is something else.
No, 44 of this bunch, my lord.
This bunch, yes.
Yes. My lord,
This is a
this is the-
Bengali something.
Huh? কি রে?
44. Yes.
যা বাবা, তো আমাকে একটা জজ সাহেবকে আর একটা দিয়েছিস। আমার 44 তো
44 is probably loan application or something.
No, 13(2) টা বার কর, তাহলে এখানে কোথায় চট করে। মানে I was given a different bunch.
This Ojha at her best.
Page 37, my lord, I'm sorry. Page 37.
Yes, 37.
Yes. My lord, this is, my lord, the sufficiency notice. Then, my lord, there is a notice at page 39. 37 is a demand notice. 39 is, my lord, the sufficiency demand notice.
13(2). This is 13.
Yes, 39 is 13(2).
But they cannot.
Fourth stage, my lord, we have not reached yet.
But till you 13(4) only debarks them from.
No, my lord, section 34 of the Sufficiency Act, my lord, has, my lord, twofold. Kindly take, my lord, section 34. Securitization Act.
Securitization Act. Securitization Act.
My lord, kindly take this. আমার বইটা খোলতে বসে আছো?
সাবধান, খুব আস্তে এটা। এতে পড়ে গেলে চিত্তির হয়ে যাবে।
দুইজন জজ সাহেবই পেয়েছে? ওটাই জজ সাহেব। Kindly see, my lord, the language of section 34. No civil court shall have jurisdiction to entertain any suit. This is, my lord, number 1, or proceeding in respect of any matter which a debts recovery tribunal.
Which section? Which section?
34, my lord. I'm sorry.
30. Yes, the bar.
3, the bar. My lord, which ousts, my lord, the jurisdiction of a civil court.
Yes.
No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debts recovery tribunal or the appellate tribunal is empowered by or under this act to determine, and no injunction, my lord, this is second prohibition, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. So, my lord, no injunction in respect of any action to be taken in pursuance of this act is also covered. That's, my lord, the language of section 34. Now, my lord, here, otherwise also, my lord, this learned court could not have had the jurisdiction. Kindly see, my lord, the schedule to the plaint once at page 35 of my stay application. My lord, this is a Tala property. My lord, injunction is granted by city civil court. My lord, this is out and out a suit for land.
Challenging the loan transaction which took place within this.
My lord, this is out and out a suit for land. Because, my lord, he is asking for, my lord, he is trying to, my lord, establish his right, the plaintiff's right, my lord, in respect of the immovable property. My lord, they want an injunction that I do not disturb their possession, I do not sell, alienate, transfer the property.
The entire reliefs are sought in respect of the loan only.
Kindly, my lord, have a look at the prayers.
It is not disputed. Because the moment you took the property as a security, you admitted their rights in a sense.
No, my lord, kindly see prayer C at page 33. My lord, this is
release the property.
Yes.
This is consequential to A. They say the loan is bad. They never received the loan. Somebody else mortgaging their property took the loan.
But, my lord, section 16, of course, my lord, subject to correction by your lordship. Section 16 of the Code of Civil Procedure says, my lord, any right in respect of any property, immovable property. My lord,
We have to see the principal relief.
Very.
Territorial jurisdiction.
These are then, my lord, consequential.
No, let us see the impugned order ones.
Yes, my lord. And, my lord, one more thing. My lord, they have made out a case that, my lord, this Shekhar, my lord, the defendant number 3, he, my lord, made a declaration. When, my lord, they could come to learn about this loan transaction, according to them, they, my lord,
But Mr. Banerjee, they are they are seeking a declaration hitting at the root of the loan transaction itself. They say that was fraudulent.
On the basis, my lord, of
The loan agreement is admitted by them.
They say Shekhar has done this.
No, but they were mentioned as the borrower.
Yes.
Plenty were mentioned as
Yes,
the
my lord,
borrower.
those documents are annexed here. But, my lord, before coming to that also, my lord, they have made out a case that, my lord, this defendant number 3, Shaurabh, who is, my lord, their nephew, my lord, after, my lord, they came to learn about all this loan transaction, they, my lord, caught hold of, my lord, Shaurabh. Shaurabh made a declaration saying that he has done this mischief.
That was that page page
Yes,
44.
yes. Kindly, my lord, have a look at that declaration once. My lord, it has got nothing to do with
That
HDFC.
is between them. That is between them.
Again, my lord, that declaration, if I take it on the face value, even then, my lord, that declaration has nothing to do with, my lord, my bank. It's, my lord, with regard to Axis Bank. Kindly see. And, my lord, Shaurabh says this, when, my lord, kindly have a look at the loan documents once. Kindly take, my lord, page 50 and 554. But, my lord, these are documents which, my lord, I have covered under Order 41, Rule 27. That's true. Page, my lord, 50 and 54. My lord, will kindly get, my lord, the signature of Anup Ghosh, my lord, on the left hand side at page 50. My lord, he is one of the plaintiffs. And, my lord, 54 is the other plaintiff.
Can the tribunal decide, I mean, grant this relief? Relief A, let us see that. Under
Yes, my
section
lord,
17.
Yes, yes.
Section 17 is the governing provision.
Yes, my lord. But section 70, my lord, one can approach once 13.4 is, my lord, resorted to. Not, my lord, before that.
Yes, so they will have no relief, no remedy now if they don't approach the civil court.
But, my lord, no injunction in respect of any action which is proposed to be taken by the bank under the provisions of this act.
Then they would be remediless if that proposition is taken to its.
It's because, my lord, it's premature a
logical.
challenge. It's premature a challenge.
Shall be granted by any court or other evidence. No injunction shall be granted by any court or other authority in respect of any action taken or to be taken.
To be taken.
Let us see section 17.
Yes, my lord. Any person. I'm sorry.
What is the
Miss opening words of, my lord, any person, which, my lord, covers them also, including borrower, aggrieved by any of the measures taken under subsection 4 of section 13 taken by the secured creditor or his authorized officer may make an application along with
No, the core of the provision of section 17 is your subsection 2.
Yes, my lord.
What is the consideration?
The debts recovery
2 and
tribunal.
3, yes.
Yes.
Shall consider what? Whether any measures under
Subsection 3. After examining the facts, comes to the conclusion that any of the measures referred to in 13.4.
3 is derived from 2. 2 says debts recovery tribunal shall consider whether
any of the measures referred to in 13.4
measures taken by the security
are in accordance with the provisions of this act, which covers, my lord, whether loan is proper
and
or not.
he says if the debts recovery tribunal, after examining the facts and circumstances, comes to the conclusion that any of the measures referred to in subsection 4 of section 13 are not in accordance with the provisions of the act, then 13.4 stage has not yet come.
Yeah.
Now they would be then you would be hit by UB just IB remedium. This relief cannot be granted by the tribunal.
This relief can be granted by the relief.
A cannot be granted.
As of
Rest are
now, no.
consequential.
As of now, no. But, my lord,
no, at no point of time this declaration cannot be given by the tribunal that the loans disbursed are.
My lord, if they can establish that, my lord, their signatures has been forged and manufactured,
yes,
and then, my lord, the mortgage also become bad. So, my lord, it, my lord, ceases to become secured asset, and, my lord, DRT.
Under which provision does the debts recovery tribunal give this declaration?
That
or
will
decide this issue? Tell us. Show us one provision.
My lord, under 17.2 only, my lord, these are, my lord, interpreted by, my lord, the honorable courts. My lord, I am today not armed with, my lord, those decisions.
Comes
but
to the conclusion that any of the measures not in accordance with the provisions of the act. That is broad.
Yes. And, my lord, what is, my lord, a measure? What is a secured asset? Those are all defined under this act. What is mortgage? Who is a borrower?
So, within that broader question, whether
my lord, their case is, my lord, if I may put it, my lord, simply, their case is that they are not borrowers as defined under the act. So that is what is, my lord, the DRT's lookout. Because, my lord, I can take possession of a property which is, my lord, mortgaged. And, my lord, mortgager is, my lord, within the definition of borrower. So, my lord, their case is simply this, that, my lord, they are not borrowers as defined under the SARFAESI Act. That is their case. And that is, my lord, for only DRT, my lord, DRT has the exclusive jurisdiction to decide that.
Will admit the appeal but not grant any stay at this stage. We are thinking about stay because palpably, especially this is bad. But as of today, if suppose they have their plaint is ultimately, their suit is ultimately allowed and the debt is declared to be bad.
Lord, before a quorum non-judice, my lord, my lord, hit at the root
Not
of the
yet,
matter.
before 13.4. Before 13.4,
Because of, my lord, the second part of section 34, my lord, even before
no, for an
34.
anticipated action, we can presently they are anticipating this. 34, let us
Yes,
have a
my lord.
relook at
Yes,
it.
my lord. My lord, this is kind of, my lord, if I am not wrong, injunction kiatiment, which is, my lord, prohibited. No injunction shall be granted by any court in respect of any action to be taken in pursuance of any power conferred by or under this act.
This prevents you from taking out 13.4 also.
Yes. Not to sell, transfer, alienate, everything, which are, my lord, my statutory rights.
কি করবো স্টে করবো অপারেশন 13.4 এর নোটিশ ইস্যু করতে পারবে না ব্যাংক
My lord, may I make a suggestion? My lord, I understand, my lord, that trouble, my lord, that is passing through my lord's mind. My lord, we are at the 13.2 stage. Physical possession, my lord, is a long process. We have to approach, my lord, learned magistrate, make an application, adjudication, then take possession. So that will take some time. My lord, even if I, my lord, want to, my lord, throw them out, I cannot
you are
do that.
seeking an opening for at least issuing a 13.4 notice and taking
symbolic possession. So, my lord, kindly stay this for a limited period. I'll serve them notice and come back, my lord, as early as possible. By that time, my lord, physical possession, my lord, will not be, my lord, possible to be taken. এইটুকু করিস না, physical possession নিস না। Kindly do not record our undertaking, my lord, but
an arguable case has been made out by the appellant stroke bank inasmuch as the learned trial judge, comma, in passing the impugned order of ad interim injunction, comma, acted in contravention of section 34 of the SARFAESI Act 2002, inasmuch as under the said provision, comma, no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under the said act can be said act, full stop. Next para, we find from the tenor of the prayers made in the suit, comma, from which the present appeal arises, comma, that although the primary relief, the principal relief has been couched in evasive language to hit at the very root of the loan taken by the plaintiffs stroke respondents by alleging that their signatures on the loan document were obtained by fraud, comma, in the same breath, comma, permanent injunction has been sought prohibiting the defendant bank from taking any action whatsoever under section 13 within bracket 4 and the subsequent provisions of section 13 of the SARFAESI Act. Full stop. It is an admitted position in the plaint that the bank has proceeded up to the stage of issuance of notice under section 13 within bracket 2 of the SARFAESI Act, comma, a natural corollary and fallout of which is subsequent notice under section 13 within bracket 4 of the said act. Full stop. Hence, comma, by grant of the impugned order of injunction, comma, it prima facie appears that the learned trial judge entered into the domain of the jurisdiction of the tribunal under the SARFAESI Act by preempting any action under section 13 within bracket 4 and subsequent procedure under section 13 of the said act, comma, thereby ex facie violating the bar under section 34 of the SRPC Act. Full stop. Next para. Hence, comma, the appeal is admitted and shall be heard on the grounds as indicated above and taken in the memorandum of appeal. Full stop. In view of a strong prima facie case having been made out by the appellant bank, comma, we grant stay of operation of the impugned order till July 31, 2025 or until further order, whichever is earlier. Full stop. The appellant shall serve copies. How many plaintiffs are there?
Two plaintiffs are there.
Shall serve copies of the application as well as the memorandum of the present appeal on the plaintiff stroke respondent numbers 1 and 2, indicating that the application shall be listed for hearing on July 8, 2025, when an affidavit of service to that effect shall be filed by the appellant bank. Full stop. Service of notice on pro forma respondent numbers 3 to 6 is dispensed with for the present. Thank you.
My lord, may I also serve upon the learned advocate who is representing the plaintiffs in the learned court below?
যেখানে
In
shall serve
addition to that.
copies of the on the respondent numbers 1 and 2, comma, directly and or through their learned advocate in the trial court.
My lord, kindly also allow us, my lord, to file a supplementary affidavit because of the, my lord, omission, my lord, that has taken place. My lord, we did not annex, my lord, some documents.
আচ্ছা, on the আরেকটা line add করে দিন. On the prayer of learned counsel appearing for the appellant, comma, leave is granted to the appellant to file a supplementary affidavit to the present application. Full stop. The appellant shall serve an advance copy, shall serve advance copies of the same along with the application on the plaintiff stroke respondent numbers 1 and 2.
There is one order 41 rule 27 application as well. We'll serve that also, my lord, upon that.
Can
2
serve copies of can 1 or can 2 দুটোই করে দিন. Are along with the memo
and supplementary. Grateful.
The application shall appear returnable date দিলাম তো
8th of July.
Applications করে দিন. Applications করে দিন. Applications shall appear. মানে can 1 of 2020 and can 2 of 2020 shall be মানে next appear on such. Grateful.
Number 24.
Suit for partition, I am the plaintiff.
You are for the other side. কি বই?
And take it back later. Deals? Oh, sorry.
Yes.
Lord, suit for partition, I am the plaintiff. Lord, I obtain an order of injunction. Lord,
Take the mic towards you.
Lord, this is the suit for
For injunction, yes.
Partition and injunction, I am the plaintiff. Lord, I obtain the order of injunction. Lord, I am not praying for setting aside of this order impugned. Lord, I am this appeal has been filed for modification and clarification of the latter part of the order impugned. Kindly come to page 92 of the Lord, the can 2, can 1.
You are placing the impugned order?
Yes, Lord.
We are looking at the memo, the last page. Yes.
Yes, that is. Accordingly, the defendant number 10 to 12, their main agent associates thereby restrain from alienating the suit property or any portion thereof to the third party till disposal of the suit. I am not aggrieved by this portion. Next, they are also hereby restrained from changing the nature and character of the vacant land.
You are the defendants in the suit.
I am the plaintiff.
So you prayed for injunction.
Yes, what I pray for, the nature and character should be in respect of the entire scheduled property. Because
so you are aggrieved with the refusal regarding the other portions of the property than the vacant land.
Vacant land. Yes, Lord. Because of the fact, Lord, kindly come to the order page 60. Lord, kindly come to page.
No, but we can't understand this. Your allegation is again defendant numbers 10 to 12.
Yes. They are making construction. Lord, page 51, my lord will get.
No, I mean, we don't understand this. The court granted you injunction regarding the entire property, the other portion of the injunction.
No,
but
Lord,
why was it restricted in case of nature character?
Yes, Lord, the latter portion, they are hereby restrained from changing the nature and character of the vacant land.
Why this discrepancy?
Lord,
Is it explained?
That is the reason for which this appeal has been filed, Lord.
Was there anything in your averments in that
No,
they are
Lord,
trying to
even
change
I am
only that portion?
No, Lord, I am showing the page 77, the first order. There, Lord, the status quo in respect of the whole property. 77 though.
Show us your application for injunction. Show us your allegation that they are making trying to change nature character.
Lord, I am showing one page, Lord, page 51.
পুরোটাই তো বুঝিয়েছে ওরা।
Lord, kindly come to page 51. That is
No, we will admit. The plaintiff in a suit for partition has come up in the present appeal against the portion of the impugned order whereby the prayer for injunction with regard to change of nature and character of the suit property made by the plaintiff stroke appellant is deemed to have been refused in respect of the rest of the co-schedule suit property apart from the vacant land lying thereon. Full next parallel and counsel for the appellant points out that at the ad interim stage, status quo had been granted in respect of the entire property. Full stop. Even in the earlier part of the impugned order, injunction regarding alienation of the suit property has been passed against the defendant numbers 10 to 12 and their men and agents, pertaining to the entire suit property. Full stop. Next para. As such, prima facie, we do not find any justification either in the reasoning portion or the ordering portion of the impugned order to restrict the injunction regarding change of nature and character only to the vacant portion of the co-scheduled property. Full stop. Accordingly, the appeal is admitted and shall be heard on the above questions and the other grounds taken in the memorandum of appeal. Full stop. The respondent numbers, they are also 10 and 12 here. 10
and 12.
Respondent numbers 10 to 12.
Yes, Lord. 10
and or their men and agents shall remain restrained by an order of injunction from changing the nature and character in respect of the entire suit property till disposal of the present application. Full stop. Next para. The appellant shall serve copies of the injunction application on the respondent numbers 10 to 12, indicating that the application shall be listed for hearing on July 9, 2025, when an affidavit of service shall be filed by the appellant. Full stop. Service on the other respondents is dispensed with for the present.
Great.
The entire relief claim in the appeal is against 10 to 12.
Yes, sir.
You should have made them the respondent and the other pro forma.
Yeah. Appealing for responding claim, declare Mr. Satyajit Talukar.
Paper.
Document.
Yes.
Yes.
Yes, Mr.
Yes, my lord. My lord, yesterday I had placed before your lordships several documents, my lord,
Yes,
of
yes.
the work of construction.
We are short of pink slips. We are short of pink slips.
Pink slips.
We are short of pink slips. All have been
Pink slips.
exhausted in your matter.
My lord,
No, don't cite too many other documents. Just give us the
my
brief.
lord, in fact, we can arrange for.
Yes.
Post it also.
No, you are arranging for. It's public money with which we are buying these things.
Yes.
Not our own, not from our pocket.
Yes.
Yes.
No, I'll not cite, my lord, many documents, my lord, per se
Yes.
and except which are relevant. My lord, on the last occasion, I had placed before lordship the
municipal building committee resolution that the plan was examined and we were called upon to comply with the other departmental requirements, that is clearance from concerned traffic department, fire services, microwave clearance,
Yes, yes.
and the respective departments.
You did everything that could be done, but Kolkata Municipal Corporation was withholding that sanction
Yes.
for certain reasons for which you are not liable. And that 3 years is circumscribed by the fact that with a valid sanction plan.
Yes.
So
And
if the
other statutory requirements.
other statutory requirements, so you are doing the rest.
Yes.
If the sanction plan was not received, it was not your fault that it could not complete.
No, my lord.
Two grounds, they terminated on 2 grounds probably, that
Only
and some
one
other.
ground specifically.
Only that three years construction.
Yes, 3 years construction. The rest of the grounds, my lord, in fact, 2 grounds were added in the order, but they do not find reflection in the SOCO's notice. And they went at all even.
Like?
If I should, I shall show the license deed. 5, 4, and 7.
What is the page number, Ms. Agrawal?
I shall give you lordship. देख लाइसेंस डेट पता बोलो तो लिस्ट ऑफ डेट्स से क्या बोलो too many papers my lord.
Yes.
It is 22nd May 2003, page 40, page 40.
Page 40 of part 2.
40 part 2.
That is the deed of license.
Deed of license. And if your lordship takes the order which was passed.
Yes,
then
that
it
is
will
what
be
will.
clear. SOCO's notice is at page 137.
No, you are not challenging the show cause, you are challenging the order itself.
Yes. In fact, in SOCO's we have replied. In
Yes.
Oh, my lord. I'm just reading from the middle instead of reading the entire paragraph. However, it appears that you have not taken any steps for construction of the project. I hereby give you notice that the deed of license dated May 22, 2003 between KMD of the one part and you on the other part contained inter alia, following covenants to be observed and performed on your part via clause 5.3 and clause 5.8 of the license deed. The said license deed also provides for cancellation of the license deed and consequential right of re-entry in the said property on violation inter alia of any such covenants. As you have violated the covenants of the license deed, as is specifically mentioned above, I hereby give you notice to appear before the undersigned on January 8, 2008 at 11 a.m. to explain the reasons why the license deed could not be followed. It should be, could not be cancelled rather, it should have been.
Clause 3 and 5.8.
5.8. Now, we will kindly take clause 5.3 and 8.
3 and
This is
5.
at page 42.
Yes.
3 is the construction clause, my lord. Construction clause itself, my lord, does not say that the time is of the essence of contract or that for non-completion of the construction within 3
But
years.
we'll take your worst case, we'll read that along with the other. You
I
fairly submitted, yes.
I've submitted that.
Yes.
Clause 5.8 kindly take. Next page. Not to use or allowed to use the land or any other structure erected thereon or any part thereof for any purpose other than
What have you done with that? You have sublet?
No, I have not done anything. I have a showroom. I had a showroom of 5,000 square feet
Showroom of what?
of the food items only. Haldiram. There is no reason why they are
Supermarket, it comes within supermarket come food processing unit.
unit along with residential
Most probably, Ms. Agarwal, they misprinted 5, 3 and 7. 7 was misprinted as 8.
So 7 could not have been, my lord, because subsequently I had shown to your lordship in the month of June 2023, they have given 2003. they
No,
have
5
given-
Roman 7.
Yes, my lord. Not to assign or transfer the land or any part thereof and or any structure or construction they erected thereof or any part thereof.
No, not
without-
this, not this, not this.
This could not have been, my lord.
Right.
This could not have been because I was given the right to sublease.
No, not this.
But they were themselves not aware, my lord, what they were invoking.
Right.
But
They should have rather clubbed 7-1 with this.
yes, 7-1 they ought to have been
That
written.
would sound
That
better.
would have better, which I had placed before, lord.
Yes, right.
That 7-1 is the only clause, my lord.
So 5-8, you say there is no proof even.
There is no proof.
Nothing. Very well.
And now, my lord,
Where
can
is
we
that
come
order?
to the
Yes.
order? Order is 8th January 2008. December 2007, page 137.
That is a show cause.
So cause, and then our reply is on 8th of January.
No, where is that order?
Yes, I'm coming. We're just reading. No, 139 is our letter. We list of dates.
Not there.
And it is there, my lord. My lord, it is at right, 27. Letter dated 2nd of February 2008. It is there, page 178. It is in the compilation, my lord, the heading is given wrong. Complaint letter. It should have been the termination letter.
Hmm. 178 is something else. Something to the OC.
It is our complaint.
You wrote to those.
Termination order.
That is not there at
Yes,
178.
my lord, it is at page 185. 1st February 2008. Exhibit 66, letter from KMDA to Haldiram Limited. 1st February 2008, my lord, page 185. My lord,
Yes.
my lord, if I read the order, my lord, let me read the entire order. This is necessary.
Yes.
This is in pursuance of the SOCO's notice issued by KMDA.
Read the entire order or till 3 minutes, whichever is earlier.
Yes,
Yes.
because it is necessary. Otherwise,
Because
I
you
will
have
not
3 minutes, that's why.
Yes. The fact that you have not constructed. And my lord, first line is your representative was heard at length on January 8, 2008. My lord, but there no hearing had taken place rather.
Oh.
We have given a written submission. We were called upon to go. And we have deposed with regard thereto. And all his submissions have been taken into consideration. Then, my lord, the fact that you have not constructed and set up a supermarket cum food processing unit with some residences to the staff within the time period of 3 years from the date of grant of license on 22nd May 2003 appears to be an admitted fact. Your explanation that the land title is not clear is not accepted, as because to this date you have not even once informed KMDA of any defect in land title, my lord. Now, this point could not have been taken because the deed of license itself contained the fact that the title with the KMDA was not clear. You have not even informed that KMDA that the project is being held up because of defect in land title. From the property tax receipt enclosed with your letter, it is evident that your name has been entered in the record of the municipality as a licensee of the above plot proving that from KMC's point of view, there has never been any dispute as to the status of the land. Even in the absence of this, it is evident from the documents submitted by you that you are the licensee and KMDA the licensor. The question of further clarification to KMC in this regard does not arise, as because KMC has already entered your name in their record in respect of the plot of land in question, and KMC has not rendered any matter in this respect to KMDA. Your application dated 10th March 2006 to the West Bengal Pollution Board for NOC on the face of it is grossly delayed, and it is almost 3 years after the license grant agreement. As per the relevant provisions in the license agreement, the project should have in fact been completed by this time. You have contended that you have taken some steps like applying for explosive license, etc., which are exorbitantly delayed and not supported by ground activities. There is no activity of execution of project till date on the ground, including soil testing and preliminary preparatory work. But this is absolutely false, my lord. Similarly, the building plans have not been prepared till date. Thus, there appears to be no serious endeavor on your part to set up the project for which the license was granted. The license deed was executed in order to enable you to proceed with the construction work immediately. Despite that, you have not proceeded with the implementation of the project, although you were empowered under the deed of license and had sufficient scope to erect, construct, and complete the proposed project within the given time frame. Several other allottees of KMDA have completed their projects on the basis of a license deed similar to the one granted to you. You have not even prepared the building plan till date and even could not justify your action of not doing so. Now, my lord, I shall show from the evidence that the DW2, my lord, in his deposition has said that though in many cases they had promised to execute the lease deed, but deliberately they had executed the license deed to be followed by the lease deed to be executed. And it was this was their normal course and procedure.
For others also.
For others also, that they were doing so. So the plea of the land title, if we accept their contention to be true, was from very inception, my lord, from a part of the government body, my lord, it was mala fide.
What about this delay in filing this, making these applications for explosive license and all?
My lord, I shall show, my lord, I shall.
You had shown those applications.
Those applications,
Those
they
are
were not
filed
belated. They,
about what time?
immediately, 2004 in the early part, my lord, the license was applied for.
Same year.
Same year. And my lord, the authorities took time in granting the license.
That is different,
In
but you
2000
applied.
I had applied. Then, my lord, the NOC with the Pollution Control Board, my lord, I need everything. In fact, the plant and machinery to be and the tankers to be installed.
Prior formalities were to be there.
In fact, in September 2006, my lord, Pollution Control Board had taken inspection of the plant and machinery installed there, because for water and treatment and other effluents to be discharged.
Right.
All these things have been done. And my lord, the contention that I have not even done the soil testing and preparatory work and not even a plan has been prepared is absolutely wrong, my lord. In fact, the MBC meeting resolution I have shown to your lordship that my plan was taken for consideration. And I shall show that subsequent thereto, I had obtained all the licenses also, fire license, traffic department license, all these things.
You had already shown those on the last occasion.
Yes. Now, my lord, kindly see. It is apparent from the records. I am just reading the 4th paragraph, my lord. Apparent from the records that is and established that you have transgressed the covenant to be followed by you regarding completion of the construction of the project within a period of 3 years from the date of execution of the license deed in your favor, and whereby it shall be lawful for KMDA to determine the license and to re-enter upon the land as stipulated in the license deed. If any relaxation is made in this case, it will amount to giving undue consideration and the failure to implement the job being virtually rewarded. Then, my lord, further the land is lying vacant and neglected with just a small temporary structure that lies closed. This is also an incorrect statement, my lord. You have not taken electricity and water connection for the land. I have shown to your lordship that I had applied for high tension supply and that was being granted to me. Notes taken any steps for initiation of the infrastructure work. The position is such that the property is in danger of being encroached by third parties. My lord, this is also not correct. Immediately after taking possession of the land, my lord, I have constructed the boundary wall with the permission from the KMDA, and my lord, the property was well protected. So, my lord, all the allegations that have been made in the order, my lord, against my client, my lord, are without any basis. Then, my lord, kindly in the middle of the paragraph, my lord, page 187, my lord. Which is very important. They cannot compare, my lord, of food processing industry with regard to the setting up of a school, college, or industry. Because, my lord, the buildings so constructed therein would be simply sitter, my lord, a plan to be sanctioned, foundation being laid down, and a construction being made. KMD allotted land to different parties in this prime area for the purpose of implementing public utility services to set up business centers, industrial institutions for economic development, and for construction of commercial and cultural complex in the interest of society and public good. Time is an essence in the implementation of these development projects. The particular allotment has lost all relevance and the land is lying unutilized for long. No, this is absolutely incorrect, my lord, here. My lord, then, my lord, kindly see page 188. The license was granted to you with the object that you would set up a supermarket cum food processing unit at the site which will provide economic boost to the area. However, there has been a total failure on your part in achieving this objective for the reasons aforesaid. You are in breach of inter alia covenants 5, 3, 4, and 13 of the license deed, and therefore the license is hereby cancelled. KMDA would now proceed to take physical possession of the land and issue refund of the amounts paid by you in consideration of the plot after due deductions as applicable. Now, my lord, kindly see 5, 3, 4, and 13.
Water supply and electricity connection have already obtained.
Yes.
And this nuisance that it is never alleged by them also.
Yes, it was never alleged.
What are they doing? 4 and 13 are absolutely
Keep
misconceived.
the land clean. 4 is to keep the land clean and free from all sorts of nuisance and not to allow heavy accumulation of water in it.
3 is the only relevant provision.
3 is the only relevant provision, my lord. And in fact, my lord, they could not have taken a clause in the order for which I have not been given any opportunity to explain. The order contains the clause, my lord, which is rewards the so-called notice.
4 and 7, they could not have resorted.
And my lord, 5, 3 also, my lord, they could not have any reason.
He was mentioned in the show cause.
He was mentioned in the
You
so-called.
filed a written submission.
Yes. I filed a
Your
written
representative was present, that was recorded.
Yes. My representative was present. My
You
lord,
never know whether he was heard or not. Your allegation versus their allegation.
but my lord, in we have the person concerned who had attended the hearing also, my lord, he has deposed. And in fact, in the writ petition, we had taken the point. But what has happened, my lord, this order was made on 8th of January 2008. But the order was not communicated to us. Then, my lord, they had tried to take the forcible possession. Then we filed a writ petition before this honorable court. In that writ petition also, we took this point that we were not given any opportunity of hearing. Then, my lord, during the pendency of the writ petition, when it was being heard, my lord, then this order came into existence, my lord. It was served to us after 1 month. So, my lord, we had to withdraw that writ petition and file afresh. So, my lord, it is not a fact that we have not contended from inception. Before even the order came into existence, my lord, we had taken the point that we were not given opportunity of hearing. In fact, that was one of the ground, my lord, in the writ petition, my lord. And my lord, in fact, KMDA could not have tried to take the forcible possession of the land from us. And this is not the first time, my lord. Firstly, they had attempted to do so in 2008 and then again in 2023. My lord, even a trespasser, my lord, could not have been evicted without due process of law. And my lord, if my license has been terminated without communicating the order to me, if they tried to dispose as a person, my lord, they could not have done. And then again, when this appeal was pending, my lord, during the pendency of the appeal, my lord, they had again tried to dispossess us, my lord, without writing any letter. For this regard, my lord, for restitution of my possession, my lord, we have filed an application, my lord. This which is appearing as
They
case
have
number
taken
4.
possession.
Huh?
They have taken possession.
Yes, when the matter was being heard, it was being heard by the Honorable Court, my lord. In fact, the learned advocate said, we are not doing anything, we are just inspecting the premises. And my lord, immediately, my lord, and the news came to us, my lord, in the court.
What was being heard? The suit?
No, the application.
Writ petition?
No, this appeal. When this appeal, my lord, we had, the first day they had tried to take the possession. We immediately mentioned the matter. The court listed the matter. Then, my lord, when the matter was being heard, my lord, during that point of time, my lord, they took Passover for 1 hour, that to take up the matter instead of 2 to 3. At 1, the court, then they requested the matter to be taken up at 2. Then again, they made a request that kindly take up the matter at 3. And taking advantage of the gap of these 2 hours, my lord, they brought the bulldozer, my lord, and demolished the entire boundary wall in my entire shop.
Ask for restitution of possession?
Yes, I have applied for. This is the application.
That is also pending.
Yes, this is pending. Lord, this is the conduct, my lord, and the malafide attitude, my lord, that they want to take back the possession anyhow, my lord, by hook and or crook, my lord. It is not expected from a public body, my lord, even though it may be a contextual matter. But, my lord, they cannot take possession like this, my lord. Now, my lord, after this was being cancelled, my lord, some of the few documents, my lord, to in support of that, we have not done anything. Kindly come to page 150.
Part 1?
Part 1.
This part, only part 2. हमको बोलूंगा बाद में कल पढ़ चुकी.
Yes.
Now, my lord, this application is supported by the payment receipt, or rather, if you take page 152, this was being made on 17th of February 2006. And, my lord, all the documents were annexed. Payment was made on 15th of February 2006. And then, with the list of plant and machinery, my lord, again an application was made on 10th of March 2006 with the environmental.
What was the date of the license?
Date of the license is September.
September which year?
2006 only. They had taken inspection. Kindly take page 149.
So how could you apply for water? No, this is a consent form.
Consent to establish for discharge of effluent. The application was submitted on 17th February 2006.
But then you had not been given the license. Before the license, how could you do that?
No, this is consent to establish for is discharge of effluent. This has to be applied before. Unless you do so, my lord,
you won't get the license.
I will not get the license.
This was a part of the tender.
Yes.
Clauses.
It was to be done. Kindly see, my lord, 10th March 2006. Paying slip on United Bank of India dated 15th February 2006 of rupees 36,360 only as consent fee. Which
but
was
we need not go back to these. These were pre-tender,
yes,
pre-license conditions.
Yes, one more document which is very, very important. Page 149.
Yes. 149.
My lord, this is a notice given by the Pollution Control Board only, my lord.
Yes.
That for the purpose of inquiry under section 21, the following officers of the West Bengal Pollution Control Board, namely such and such, and the persons authorized by the board to assist them shall inspect any system of your industrial plant, any other part thereof or pertaining thereto, under management control on 11 September 2006 between 4:25 p.m. to 4:45 p.m. when all facilities requested by them for such inspections should be made available to them on the site, my lord, which, my lord, clearly shows the plant and machinery and the other effluent treatment plant which have been erected there, and the water system is required to be installed. So, my lord, by 11 September 2006, my lord, everything was complete, and we had provided the inspection to the Pollution Control Board, my lord, to take inspection on 11 September 2006. Because until unless everything is set up, my lord, by February 2006, my lord, I could not even have applied for the license before the West Bengal Pollution Control Board. Lordship has seen that the explosive license was granted on 10 December 2004. Then the approval was given by the HPCL on 31st December 2004 for setting up of the tanks, which was being done when everything was complete, my lord. Then we applied for our Pollution Control Board license. And, my lord, after plant and machineries were installed, my lord, then the authorities concerned had taken the inspection, my lord. Otherwise, we could not have been given the allowed them to take inspection. So, my lord, it is wrongful to contend that we have not taken any step. This is one part of the story. So, what inspection?
What was the follow-up of this?
Uh,
You may not have a copy of that, but even then,
Well, I
the
should-
inspection might have revealed that there is nothing on the plot.
let me just take one instruction once.
Well, yes.
I shall. अपन लाइसेंस ग्रांट हो गया ओके पोल्यूशन कंट्रोल हो गया नहीं कंसेंट टू स्टेब्लिश हो गया नहीं वो हट गया लाइसेंस My lord, I am told after inspection they had given the license because the report may not be available for the public purpose.
License is annexed.
Right, let me see if it is annexed. My lord, this is an admitted position. The authority himself, my lord, the judge, the learned court below, in her order also has recorded that we have obtained the license, but belatedly.
But we have to see that.
But I shall show to your lordship.
Everything has been captioned as letters.
Yes.
Most of them. Even the termination letter.
Yes.
No pollution license appears to have been issued.
It ought to have been, my lord. I shall find out and
Later,
produce.
you can carry on.
Yes, I shall produce.
In any event, they allege that you did not take steps for taking pollution license.
Yes.
So steps have been taken. That is evident from the inspection notice.
It is there, and they have taken the inspection of the affluents and the plant and the machinery which have been installed there. Therefore, it cannot be said that we have not taken.
That you were saying, but that for that we want to see the license
Yes,
or
that-
the report.
Yes.
But that is one of the allegations in the impute
My lord,
terms.
that is one part.
So that is one part.
That is one part, my lord, that we had applied for the license in the year 2006. And this is what the learned judge has gone, my lord. That even the KMDA Special Secretary, my lord, that application with the Pollution Control Board has been made in the month of February 2006. But I take that on the face of it. My lord, I could have applied for the application for consent to establish after everything is made ready. Before that, my lord, I could not have applied for, because in order to have obtain the license, my lord, I had to satisfy the authorities concerned.
Yes, that to submit it. That those have to be there. Installation
Installation has to be there. So, my lord, that was the ground that has been urged is that there has been a delay in submitting the application for consent to establish. They do not say that I have not obtained the license, that my application was belated. That is one of the ground that has been taken. So, my lord, that is there. And another part is, my lord, sanction of the plan by the Calcutta Municipal Corporation.
Yes.
My lord, that is a different thing, my lord, with regard to the construction of the building and other facilities, my lord, that we required sanction from the KMC. And my lord, I shall show to your lordship, even till 2008, my lord, the detailed scrutiny report was submitted on 7th of January 2008. And the date of the order is 8 January 2008. And the hearing had taken place on 31st December 2007. Then, my lord, I shall... My lord, page 123 is also relevant, my lord, whereby, my lord, the West Bengal Pollution Control Board on 5th of June 2006 has sought for several clarification in documents against our application, NOC application for proposed unit for manufacturing sweets and snacks at such and such. You are therefore requested to meet with the undersigned within 7 days for early disposal of your said NOC application. And thereafter the inspection was being fixed. So it is not that merely after we made the application and set tight over the issue, my lord. It was, we are duly following up the matter. Then, my lord, kindly come to, there are several letters, my lord, galore, wherefrom it would appear that so many letters we have given to the KMD authorities. For time to time, starts from page 126.
Everything you have annexed, in fact.
Yes.
Everything you have annexed.
And none of the documents were objected by them, my lord.
All these were marked exhibits.
All these have been marked exhibits.
As many, almost 100 exhibits probably.
Yes. Then, my lord, kindly see, to set up such a huge industry, my lord,
Yes.
You require loan from the bank.
Yes.
Without that, you cannot set up the industry. However, as the lease deed was not executed, my lord, the project was being financed by my client, my lord, on its own resources. That would be evident from page 168. So it is not that I had invested only 8 crores of rupees in acquiring the land, but several other investments were being made. Page 168, kindly come.
Yes.
This has reference to the request for loan for the construction of such and such. In this context, we like to inform you that the license deed submitted in this respect is not registered. Kindly submit us the registered deed to enable us to take further action in this regard. Till such time the proposal submitted to us is returned, kindly acknowledge receipt. This is a letter of 4th April 2006. And my lord, then...
So loan has been refused because we don't have
Because I did not have the registered land. And in fact, all the plant, machinery, everything was being done, my lord.
But loan for setting up a business need not, does not require you to have a registered deed. You had that license deed and other thing. Anyway,
But
that's a
it was
different
not
thing.
simply set up business because we required to make the construction also.
If
And
you
it
have
was
to submit a scheme, you have to submit a scheme.
project. And we were to construct a G+4 storage structure also, my lord.
Yes, but before the structure, you would take the loan, obviously.
Yes. So, in fact, the loan
If
was
you submit a proper scheme, then it should have been granted. That's a different story altogether, though.
because it was merely a license deed. My lord, there is a difference between the lease and the license. And my lord, a licensee is a licensee only, my lord.
True.
It cannot have that no resemblance of title is passed through the license. Even if I have a lease deed for 99 years or 30 years, my lord, then it is equivalent to the conveyance, my lord. Because my right to the property is not being subjected to. But the license can be terminated at any stage, my lord, because I am always at the mercy of the grantor. Then my lord, kindly take page 162, which I had not shown to your lordship. But how far the authorities have not considered the documents while considering my representation, my lord, kindly see. Page 162. This is the NOC granted by the Fire Services Department for construction. Then, my lord, at page 167 is the consent granted by the Microwave Survey Division, Bharat Sanchar Nigam Limited. Clearance of height of proposed multi-stored building at premises number 1726 Rajatanga Main Road. The application was made on 23rd of February 2005 and the clearance was given on 6th of August 2005. Then, my lord, kindly take page 169. My lord, this is the detailed scrutiny report. My lord, was submitted, my lord, with the Kolkata Municipal Corporation by us on 20th December 2005, which was being surveyed and, my lord, handed over to us on 7th of January 2008, my lord, under section 393, process category MBC.
No, it was submitted 28th December 2005.
Yes, we had a plan was submitted on 28th of December 2005. And this detailed scrutiny report is, my lord, though the date is not here, my lord, but while I was going through the evidence, my lord, I found that this is dated 7th of January 2008. So, my lord, in fact, the department had made the scrutiny in presence of the LBS, my lord, and the surveyor, and the scrutiny report was submitted on 7th of January 2008.
Yes, it is there. Page 170 at the bottom. Signature. With
Yes,
the
it is.
signature.
Yes, it is. So, my lord, it is not that we were not proceeding with the plan also, my lord. It is even after the SOCO's notice was being issued, my lord, and our representation was being made, we came into position later on, my lord, after our reply was being submitted. Because it is dated 7th of January 2008. So, my lord, there is no fault on our part, my lord, in proceeding with the matter. And your lordship will find the authority concerned, my lord, had not considered even any of our document, save and except a date was being picked up that you had applied with the Pollution Control Board on 10th of March 2006. But all these documents, my lord, which were all submitted along with my application, my lord, were not being considered, my lord, and an order was being made. Then, my lord, after the, now kindly take the first, it's very important. Page 139. My lord, submissions deposited during hearing on 8 January 2008 and we had submitted all the relevant documents along with this. The entire bunch of documents, my lord, which I had shown to your lordship, I had submitted with them. Now, from pages, I'll not take to each of the pages to your lordship, but from pages 126 to 136 or 135, my lord, your lordship will find all these letters are the letters which we had given to the KMDA from time to time that please execute the lease deed because we are facing difficulty and the corporation is not sanctioning the plan. But, my lord, none of the letters was being replied to. In fact, one important document is, my lord, at page 126.
That means, Agarwal, if you win the appeal today, how soon can you set it up? I mean, what is left to be done?
My lord, they have demolished everything. They have, with the help of 2 bulldozers, my lord, I will show the photographs. that they have demolished whatever I have done. So, my lord, I had to do it, but my lord, if I take the instruction, my lord, tomorrow I'll be able to tell you. Maybe within 2 years, my lord, everything can be completed, my lord. If the plan is sanctioned, my lord, we will restart the entire process, we will do it. And my lord, my client's financial capability, my lord, cannot be questioned, my lord, because they are set up several factories in Singur, in Domjur, food processing industry in the state of West Bengal. And my lord, when all the industries are, my lord, leaving West Bengal, my lord, my client is food processing industry is one of such industry, my lord, which we are running, and we are trying hard to maintain the same. And we are employing more than 3,000 workers, my lord, today. So, my lord, it is not that we will not be able to complete it. In fact, we are, apart from the showrooms, my lord, we are engaged in the business of export and import of food products, my lord. So, my lord, our food products, my lord, in fact, the ready-to-eat food products, apart from the snacks and the savories, my lord, ready-to-eat food products are being catered, my lord, throughout the world, my lord. So, my lord, it is an industry, my lord, if it is allowed to be sustained and remain in West Bengal, my lord, then, my lord, it will be inured to the benefit of the state of West Bengal only.
Yes.
And now, my lord, if I'll not take much time, my lord, the authorities concerned, my lord, for the first time, my lord, when the evidence in the written statement, they did not disclose any document. In the written statement, your lordship will find is a just bare denial. Bare denial that the land title is not clear. I deny that, if lordship see. I'll not take my plane, but their written statement first, which is at page 69 at part 1.
Yes.
Kindly take page 69, page 70, paragraph 7.
Hmm.
I'll not read the entire written statement, only the relevant part.
Hmm.
These defendant deny that in course of discussion, the plaintiff was informed by the defendant authorities that the title of property is yet to be cleared by the land acquisition department. The defendant also denied that the allegation till such clearance is being given, the plot can be registered as a license deed, and the said deed will be automatically be converted into a lease with power to grant sublease after clearance of the title from the land acquisition department. But this is exactly what the license deed is, and they are denying. The next paragraph also, my lord, they have denied. Paragraph 8. This defendant denied the allegation that pending execution of the lease deed upon clearance of title by the land acquisition department, the plaintiff agreed to execute the license deed, which was to be automatically converted to a lease deed. Again, the same paragraph, your lordship, they had reiterated later on also. In fact, my lord, in the written statement, they have even denied that I was being called upon to deposit 5% of the amount. Paragraph 13. It was, my lord, denial is just bare denial. Each and every statement has to be denied without even looking into the documents. The only contention that has been made is paragraph 20, is that this defendant
Yes.
state that the plaintiff was bound to complete the
We have seen that is the only statement.
That is
made.
the only positive statement.
And the other, wherever they have said state, they have stated that defendant state that those are mostly matters of record.
Yes.
So the statements are only that. Apart
Only
from that,
statement.
para 20.
From that, there is no other. And my lord, they had denied everything.
We are still trying to find out any positive assertion.
This is the only one I have found.
Yes, still now we have also found only this.
And then paragraph 40, your lordship will find.
40.
40 at page
Yes,
83.
yes. Since has not taken
That,
steps.
taken any steps for construction of the project, and a license deed executed in favor of the plaintiff are liable to be cancelled for the said reason. The defendant called upon the plaintiff to appear on 8 January 2008 and directed the defendants to explain as to why the said license deed shall not be cancelled. These defendants state that in terms of the deed of license, the plaintiff has not started construction over the suit property which is required to be completed within 3 years, and as such, they are not entitled to any order of injunction as spread forth.
Also para 41 and para
41.
44. Yes.
Apart from that, my lord, it is
Delay. Para
delay.
41, 44 also same.
44, the defendant says plaintiff has
Same,
made
same.
delay in applying for getting permission from the appropriate authorities for starting construction over the said plot of land in terms of the deed of lease. There is no deed of lease, my lord.
The delay has been repeated in para
Yes.
49 also.
Yes,
Same thing.
same thing.
Making application
It is
to
just a repetition, my lord. And in fact, my lord, we had-
it's like you have not studied for the examination. When the questions are set, you answer. You put in the same things in different places, taking a
Yes.
chance that the examiner does not look into it and make it bulky.
yes, correct, my lord. In fact, when
Here the examiner is finding out that the same statement has been put in
Repeated.
several repeated.
my lord, it is like that, my lord, at one point of time in 20, 30, 40 years before, my lord, the students used to think that more you write, more you make the bulky.
They
your
don't think so today.
I don't know, my lord, because now the multiple question systems have started, my lord, which were
Yes.
not there 40 years before. My lord, in fact, while I was in school, that point of time, my lord, some objective questions have started.
Yes.
Before that, my lord, it was only the long questions we had to answer. 10 or 15 numbers of objective questions. And but now, your lordship will see multiple questions are with there.
Not everywhere. In competitive exams, yes.
No, my lord, even in
Colleges.
schools also. Otherwise, my lord, it is so difficult to score 98, 99 and
Yes.
100.
Yes.
And it was, my lord, 40 years before, getting 60% was something, my lord, an achievement. So, my lord, this is what their written objection is, my lord, written
We have
statement.
seen their statements.
So, my lord, in fact, I should not narrate.
Need not read the entire written statement.
Yes.
Wastage of time.
Yes. No, my lord.
Did they adduce any evidence,
Yes.
documented evidence?
Yes.
We want
I-
to see those also.
Yes, I will show that. My lord, before that, my lord, I'll just show you. Or this document is the last document in the bundle, part 2.
Only one document.
2 deeds.
Deeds to show what?
That their title was clear in 1996 and 2006.
But they themselves stated to the contrary.
Is contrary.
Their license deed, they give you a license deed saying that they don't have title.
Yes. But now they have changed their stand in the suit.
In the written statement, have they stated anywhere that they had the title at that
No.
point of time?
They have just denied that that was not the ground for execution of the deed of lease.
But the license deed is not denied.
It is their license deed they have not denied, but the content of the license deed which I have narrated in the plaint, my lord,
Yes.
has been denied by them.
Yes.
Which I have shown to your lordship. How can they do so? Kindly see these 2 documents, my lord, page.
It will be interesting to hear the Advocate General.
Yes.
Or your learned friend.
My lord, kindly come to page 203.
Overwhelming documents in their favor. Overwhelming documents. I mean, almost 100 documents. Every application, everything they're very precise. I mean, their conduct of litigation is very good.
Whether they can come in the aid of the plaintiff, that's the question.
Yes, your denials are only sound.
Now, my lord,
Consistent denial.
the 2 deeds, my lord, which have been produced before the learned court below,
Yes.
my lord, one is the deed at page 203.
Why are your advertisements also given here? Some of the advertisements
Some of the advertisements show, my lord.
in several languages, Bengali, Urdu.
Yeah, because that we were running the showroom over there. It was
So
not
that
the
address
land
has been
was
given.
closed. Yes, because my lord, those have been, we have disclosed those also. And in fact, my lord, we had obtained a license from the Kolkata Municipal Corporation, my lord, big hoarding, my lord. The display is to be made and you have to take the license from the
Which one is this? Because the addresses are near Ruby Hospital. This one.
near Ruby Hospital.
That is that.
Yes, this is the place. Lordship is looking at page,
page 68. You can read from page 67 also, if you want.
yes. In fact, my lord, all these, before that, my lord,
67 you have seen?
my lord, I've seen from page 47 are the licenses which we have taken from the corporation every year
Yes.
for carrying out business, and then electricity bills and ESI's certificate, and then the page 67 my lord comes. The cell tax registration at page 63 at the said address.
67 to Urdu to us.
And then page 64, your lordship will find Eastern Metropolitan Bypass. The phone number is
Yes,
being
yes.
mentioned.
Everywhere.
All these things. And each of the page, your lordship will find thereafter 65, 66, 67.
This is সৌরভ গাঙ্গুলি খবরটাও আছে ক্যাপ্টেন করে রেখেছে
I'm grateful your lordship has found out.
Yes.
In fact, my lord, I have not shown your lordship a document that page 74. Even the tax was not paid, cleared by them within the time. They had cleared it in 2005 only, page 74. And until unless the lordship, the taxes are cleared, my lord, even you cannot proceed with the sanction of plans.
These antisocial elements are different people, not KMDA people.
Who?
You have alleged about antisocial people at page 75.
Page 75. Lord, these are different people. Because I told your lordship that we were being regularly obstructed while constructing the boundary wall, while setting up.
Naturally, that is a lucrative area.
Look, no, my lord. The thing is, still, my lord, till today, I can produce your lordship the records of that case. One Supriya Datta has still pursuing a writ petition against KMDA, wherein my client has been made as a respondent, alleging that the land was not properly acquired, which has been allotted to our client. So, my lord, there were several writ petitions, one after other, and 144 proceedings, my lord, and they were obtaining order of status quo from various forms, either from the learned executive magistrate or from the dishonorable court.
Very difficult to set up business here.
Yes.
Okay,
Number of complaints.
আমাদের যতটা সম্ভব কঠিন করে যাচ্ছে ওই জন্যই বিজনেস হয় না কি সব চলে যাচ্ছে একদমই ঠিক আছে এসব লিটিগেশন করবে না ব্যবসা করবে
My lord, here one lady claims, my lord, Shamali Das, my lord.
Shamali Das claims every property.
Yes, she had.
All of us know.
All of us know.
Rasmuni is,
Ra-
Kani Rasmuni is
yes.
descendant, yes.
She had also interfered.
She is the owner of entire Calcutta.
Entire Calcutta.
If her
Then
contention was accepted.
Roy family.
Every judge knows her, every advocate
Yes.
knows her. If you don't know Shamali Das, you are not entitled to practice in the High Court.
Nowadays, she is not seen.
She is not coming.
Yeah, now she is not coming. Nowadays, I have not seen for last 7 to 8 years.
I have not seen in my court at least, but I don't have access beyond that. So
In
some
fact,
of these people, I mean, everybody knows.
well, she's
Shamali
working-
Das does not help you.
No,
She claims every property in Calcutta.
I'm not saying, but she had in fact in this.
She has
suit
also come in
applied-
here.
Yes, she had applied for addition of party in the suit.
That was rejected. Thank
It was rejected. My lord, then my lord, one Datta family, one Bablu Datta,
There are some well-known busybodies in Calcutta. I mean,
yes,
the court
Sudeep
circles know them.
Supriya Datta, then the Roy family, they all claim that they have a title over the property, my lord. And they had obtained the injunction, my lord, pages.
Those are still pending, those suits.
My lord, we do not know the about it, but Supriya Datta writ petition is pending, my lord. And my lord, these letters, my lord, kindly see from pages 75 to 79.
Ms. Agarwal, you finish this hearing at least early so that we can dispose of this appeal. At least one somewhere you can get
Yes.
some relief.
Yes.
Even if you dismiss, you'll know that it has been dismissed. I mean, you
Yes.
can get some relief at least
Certainly, my lord. But kindly
expeditiously.
page 81.
81.
Page 81, another repetition, my lord, cause title is only there.
Need not place these things.
I will not, because
We will in any event forget. I mean, so many
I
things.
will not, why I am saying this, that when
But
the,
we have seen that we have given so many documents. They have to establish now
and now they
that
give us
their allegations were true.
productions were being caused in after taking possession in the year
We can
2004,
understand. We can very well
2005.
understand. Yes.
That your lordship can appreciate. Now, your lordship will, I will not waste your lordship's time. Kindly take these two documents, my lord, which are at page 203.
আর স্লিপ লাগাবো সব পেজে স্লিপ লাগাতে হবে ওনার হলুদ স্লিপ গুলো থেকে the number of your yellow slips have stopped me from putting in further slips here. You can understand
Two more.
Do we understand that?
Yes.
From a perusal of your number of slips, I have stopped putting in.
But I have not
All the
shown
pages are important apparently.
number of documents, my lord, in fact.
We'll now put in slips in pages which are not relevant.
Yes,
That will be an easier task.
Yes.
Indenture, what is this? Page 203, Ms. Agarwal?
Is a deed, my lord, executed by the state of West Bengal in
Yes.
favor of KMDA.
That title, oh, this is their
This
exhibit.
document, their exhibit. This is very important.
But this is exhibit 75. You
It's wrongly written, my lord, exhibit A and B.
This is A.
A. Because DW2 was recalled, my lord, and in his exhibits, in his deposition, my lord, these documents were exhibited.
All right.
Your lordship will find at page 218, it is written as exhibit A.
Same document.
Yes. Or this one was.
Yes, yes. So we will mark page 218. That will be easier. No, this is exhibit B, probably.
B.
B.
And the exhibit A is later. It's wrongly. While preparing the paper book, my lord, by the
We
department.
don't know whether this was exhibited by you also, probably.
No, we have not exhibited.
It continues up to exhibit 77. How could it come midway?
I do not know, my lord, how they have mentioned it, but
Yeah,
it is not my document.
Have you perused the records? Because
Yes, my lord, I had perused the record, my lord, even the judgment, my lord, delivered by the learned judge, my lord, records the list of exhibits.
that shows this as exhibit 75.
Yes, I shall show.
Need not show that. Leave it. Well, we are interested in the documents. Huh?
Admittedly, we have not produced this.
Very
It
well,
was
very well.
produced by them.
So where does their exhibit start from?
From this only.
It
The
cannot
two
start from B. There must be some
A is later on.
their authorization.
The resolution.
Where is that page?
How come it has gone in?
It's 216.
216 is my client's.
No, that is yours.
My lord, page 218.
Authorization letter. Yes, that is.
Authorization letter. So
So
this
this
was
is exhibit A. China.
Or my lord, the same document is again annexed at page 219. Exhibit B.
B is exhibit B is that your item 75.
Yes.
That we have seen.
Yes, that is same. Exhibit B, it is mentioned.
So you
here.
said two title deeds were
Two
produced.
title deeds.
What is the
One
other title deed?
other
219 is one.
Yes. And the other one is at page 224.
224.
22nd January 1996.
224 is A1.
A1. If, my lord, they had a title in the year 1996, my lord, then, my lord, there was no reason, my lord, that lease deed could not have been executed in my client's favor when I had purchased, applied for obtaining lease of the same. And then this one is of 13 January 2005. And, my lord, from the evidence I'll show to your lordship, they have admitted that they have not intimated us that the acquisition process is complete or they have got the title. They did not hand over these documents to us. In fact, subsequent to this deed also, my lord, letters galore, wherefrom it would be evident that we have requested them optimum number of times, my lord, to execute the deed of lease in our favor. But there was no reply to any of the letter. In fact, we have written a letter, my lord, I shall indicate for one of the page. We have requested them that please issue the no objection certificate to the KMC so that the plan can be sanctioned, my lord. Even that no objection certificate was not being granted by the KMD.
They themselves said that they did not have any title.
They themselves
And
said.
their
And now they
license
are
deed
relying-
says so. License deed.
These two deeds which have been produced by them, my lord, then thereafter they ought to have executed the deed of lease in my favor, my lord. Then, my lord, I could have proceeded with the matter more faster than what it have been done.
They'll have to substantiate their grounds.
And, my lord, now,
You can, I mean, I think this is sufficient. I mean, you need not place anything else. You can cite judgments if you want.
now, my lord, I'll cite judgments, but I would like to place some of the paragraphs from my application tomorrow.
Your application for?
For restoration of possession.
All right.
That.
You can start it right now.
Very well.
Oh, I can.
एक मिनट रुक जा वो दिखा दी मिलॉर्ड छोड़ दे तो मैं दिखा चुकी ऑलरेडी दिखा चुकी मिलॉर्ड only one document from this paper book मिलॉर्ड
Yes.
and it take page 195
Done. 195 এখন বাকি আছে হ্যাঁ তুই চলছে পুরোপুরি খেলা 195
this is a RTI application, my lord, which was made by my client, my lord, with the municipal authorities, my lord. Because as a licensee, my lord, we were not even given the copy of the assessment book, my lord, and the mutation certificate. So we have, it was replied to that is a compulsory required copy of assessment book and mutation certificate before sanction of building plan. Can you sing, my lord? The English is not so good. Can you sanction the building plan without copy of assessment book and mutation certificate? The reply is at page 196. With reference to your letter dated 19 November 2009, it is to be informed that for sanction of building plan from this department under Bureau 12, any document of assessment department of KMC confirming the present ownership as recorded, that is mutation certificate assessment book is necessary, without which such sanction cannot be given. So this is one of the documents, and I'll give your lordship the copy, my lord, for one letter, my lord. I'll just indicate the page later on, that where we have requested them to give NOC, but they did not give.
But
Now,
it is like a vicious cycle.
Yes.
Because the KMDA says that you have to obtain a sanction plan first from the KMC. And KMC says unless you have a deed, something to show your title, they won't grant a sanction.
They won't grant a sanction. And my lord, I shall show, my lord, now these are the factual aspects and how the learned judge has dealt with it. That is also very important.
Yes,
Let me place that.
Show it.
It is in part 1.
मुख्यमंत्री को दी बधाई. Ironically, that is appeal. It's most ironical, page 197. You can look at the news item beside your. The chief minister is being praised by the Association of Businessmen for encouraging good business in West Bengal. Very ironical.
Yes.
Just see the irony of it.
Yes, my lord.
व्यवसायी संगठनों ने
ये सराहा।
व्यापारी संगठनों को सहारा मुख्यमंत्री को दी बधाई. So it's very ironical in your case. Anyway, let us come to the judgment. We are small fry, so let us be content with these judgments and all.
My lord, because of this attitude, my lord, in fact, the industries have
You are understanding from many matters, Ms. Agam. And it's a continuing thing. From the previous regime also,
yes, when
near the end, probably there was some attempt to change it.
Change the scenario.
Sector 5 and all these things. And see the outcome of that.
Yes, it is flourishing. But the only
Government
thing,
falls.
yes, but
Government
only thing
falls.
is, my lord, that we have so only industry which is surviving.
হ্যাঁ হ্যাঁ তাই তো তখন থেকেই চলছে
Only industry which is surviving or is flourishing is the real estate. But who will be the buyer? All, my lord, my lord, I had, in fact, in my career, my lord, I have done a lot of cases relating to the jute industry. Baranagar Jute Factory is one of such
yes
cases.
yes
Goripur, all these industries, my lord, your lordship, at one point of time, my lord, were flourishing industries, my lord, jute especially. Nowadays, my lord, the Goripur, it's lying closed since 83. Baranagar, my lord, it went into liquidation in 87. Now, my lord, SADA groups are fighting, my lord, for the NHI compensation of 200
there
crores.
is another risky thing Ms.
Yes.
Agarwal. The difficulty is real estate is booming because the inequality of income is hugely increasing. If you look at your surroundings everywhere, five-star hotels are coming up, people are coming, staying there, going away, and many things are happening. But that is restricted to the absolute cream of society,
Yes.
financially.
The person who have
Multi-storied buildings, you cannot
my
go
lord,
near
the
the facades.
52, my lord, constructed by Money Group and the Alcove, my lord. Flats
And
at
the
25 crores, 40 crores.
right. And the people are buying that.
And these
There are
people
to
are
buy
only
that.
investing in the other real estate.
There are
only.
people to buy that.
Yes.
And the surrounding these buses and all these things are being just tomorrow you won't know where those people have gone. They suddenly vanish. Sometimes there are fires.
My lord, recently Khidirpur market.
Yes.
1,300 shops have been gutted, my lord, for no reason whatsoever.
And just have a follow-up after a few months. What happened to that area? Every area. I mean, this is common to all places.
My lord, in Bombay, you also will find it is a better situation.
Better means they have a bulldozer instead of a fire.
No, what they do, my lord, that bastis, my lord, are being replaced. My lord, the builders enter into agreement with the bastis and slum areas, and they construct a building for them. And then they start the multi-story building. But the irony is that there are slum dwellers, my lord, they let out their flats to others and again start residing at the slums only.
Money because they are at the borderline of the poverty level. So they require money more than a flat. That is the difficulty.
Yes. Now, my lord, kindly take page 247.
Yes, we are there. You can come to 248, in fact. Starts at 248.
My lord, the learned judge, my lord, had recorded the contention. In fact, I will not read, it has quoted the clauses of the license deed, my lord, and letter of allotment. And then, my lord, the learned judge has quoted the payment method and
Yes.
from where it is relevant.
There are no paragraphs in the judgment. Very irritating. Not a
At
thing.
one stretch, my lord.
Yes. These are the pleadings, Mr. Agarwal. You can
Yes,
skip over.
they have quoted it from the plaint only and it has been narrated.
We are sufficiently fed up with the pleadings.
Yes, I'm not.
Particularly the written statement of your learned friend. Yes. Ball denials and all.
Yes.
Issues are at page 261.
No, my lord, kindly take page 250.
No, yes.
No, that is also not required. And then it has been quoted.
78 exhibits from your part, on your part.
Yes.
2 exhibits and 2 identifications. So.
Yes.
Oh. 19 pages devoted to this recording of these things, arguments, the pleadings, and the exhibit list.
Yes, the entire all exhibits.
Yes,
that have
and
been
4
made.
pages for the judgment.
Judgment.
Good for us. We have to read 4 pages only.
My lord, in fact, see, the learned judge has summarized all the list of the exhibits and the issues and everything. Now, my lord, I have underlined today only in the morning.
19 পাতা ধরে এক্সিবিট আর প্লেন কেসগুলো সেট আউট করে গেছে 4 পাতার জাজমেন্ট
Issue number 1 and 2.
আমরা এবার থেকে এরকম করব 100 পাতার জাজমেন্ট হবে, সুপ্রিম কোর্ট তো তাই করে। সুপ্রিম কোর্ট তো তাই করে, সব জাজমেন্ট আগেগুলো সেটা সেট আউট করে ডকুমেন্ট লিখে দেয়, তারপর 4 পাতা নিয়ে যায়। কিছু থাকে না। Yes.
My lord, issue numbers 1 and 2, my lord, the suit is maintainable. Then
Yes.
the issue numbers 3 and 4 and 5. Now, my lord, the entire prayer of plaint rests on holding a declaration valid by order of allotments dated 6th March 2003 and 7th March
Ms.
2003.
Agarwal, we can start from the decision with reasons tomorrow.
Very well.
Issues you have seen,
Very well.
exhibit list you need not place, obviously.
Yes.
And we can start from page 266, which contains the decision with reason.
Very well.
That is the crux of the judgment.
Yes. Then shall we do it tomorrow?
No, yes, tomorrow. Tomorrow is the hearing day. We'll continue tomorrow. Hard in part for further hearing tomorrow. Ms. Agarwal, you please try to finish tomorrow.
I'll try
I
to.
mean, because decision with reasons, and then if any judgment, if you want to cite, and if you don't want to cite, need not. This is a fact, case on fact mostly.
Basically, case.
Basically, case on facts, and you can those paragraphs from your restoration application.
Yes.
Restoration
Those
of course.
paragraphs are very important.
Whatever you want to cite, say.
After my learned friend finishes tomorrow.
You start immediately. Otherwise, you'll close arguments.
Another day.
No. Come tomorrow. You are getting 24 hours notice. More than 24 hours.